Last we 2005, and there was hardware, food and director for every exit. I have challenged the tribunal release of High Court.
Hearing matter.
No,
Affidavit extends this hearing matter. Please wait for some time.
The other party, the tribunal, they made an execution case, 10th February 6th of execution. For this purpose, otherwise I would have come February 1st.
You have to take out an appropriate application for that. Yes.
May I permit to mention one matter for upgradation?
Please hand over the slip mentioning the urgency.
This is for the last your lordship, item number 86. Item number 8. Some notice upon the privatization to remove the obstruction. Due to that obstruction, my egress and ingress have been.
What do you want? Please hand over the slip. Please hand over the slip mentioning the urgency. Upgradation, please hand over the slip mentioning the urgency.
I already hand over the slip.
Yes.
This matter shall take by your lordship to appear on 29th of January.
Yes, it is not appearing.
Matters are appearing in the list, but if these matters are not taken as subject to lordship fine convenience, then I have settled every day with dire consequences by the private party because on my
Always hand over the slip mentioning the urgency. Yes, sir.
Ready for hearing matter, that's why I was not.
Hearing, please wait.
Sir, your lordship considered this. This is whether I have terminated this. After termination, they have come up and challenged and gotten stay order. And state exchequer, that is the only problem.
Please wait for some time.
Yes. New motion urgencies and
new motion, please hand over the slip. Yes.
Monthly list item.
Hand over the slip. Yes, call the list. Yes, call the list. One, yes. The learned advocate.
This petition has challenged. Next
Why to be mentioned?
Actually, I want to withdraw this. This is not for the non-prosecution. After the petitions I have received from that school, the that no, your application cannot be considered as the is not an autonomous body. This is the communication that I have to challenge because this has not been challenged in the subsequent development. Yes, when after the order of the Honorable Supreme Court, I want to return my previous job because I am a job loser. Whether my service has been terminated by the order of the Supreme Court has categorically stated that.
In the read petition, what do you challenge?
Inaction on the part of the school authority,
not allowing you to rejoin. Now what happens?
Now they have communicated that no, this school is not an autonomous body. Your application has been rejected. So that has to be challenged by the face cause of action.
So you want to withdraw this with liberty to file after? Yes, you are for the school. It's a journal learned advocate.
Melody, is this item number 2? Then I am appearing for the school with Miss Bose.
Yes, it's item number 2, Mr. Bhattacharya.
Yes.
What do you have to say?
This matter has been assigned. This was mentioned before your lordship.
Now they want to withdraw this to file afresh because subsequent cause of action, they said that their prayer has been rejected now. So they have to challenge that decision. Mr. Jamal. Yes, call the next matter.
Number 3, item number 3, I am appearing on behalf of the private restaurant where I the instance of my mentioning.
Yes.
For a correction. Yes, my lord.
For correction, what is the
The last occasion, Lordship has extended to file the opposition and my lord, extension to the report of the regarding the my lord extension, my lord. Direction. Extension of the interim.
extension of the interim order?
Yes, yes. Last occasion that is come under the heading for extension
All right. Interim order was still
till January, my lord, 2020.
Did I pass any order for extension or I did not?
No, my lord,
It has been. Yes.
great thing. I think who are appearing for the state, my lord, that I
Please give your appearance. Yes, call the next matter.
item number 4. Now I have heard be wiser because you would as per indicated, I have put I want to start permission with the
What submission? Mr. Chatterjee, yesterday's observations made you come physically.
Yeah, I did not hear the order. Your lordship, whenever your lordship start dictating,
Which I wanted to make. Because there is no application under 123 rule 1 subsection 3. It's a prayer under 123 rule 1 subsection 1 read with my lord, subject to my lord, there is no provision closing the court to not pass any further direction. Once the petitioner comes under subrule 1 within subrule 4. Because the term on such terms appears under subrule 3. There is no application for liberty. Under second submission, that I don't need to submit the lordship with the rate rules for the second submission, kindly have a look at the prayers in the petition. That the prayer is for granting a direction on the authority to demarcate in terms of the Bengal survey. Now, not the Bengal survey. That's the prayer is not containing Bengal survey.
Where did you say the
Contains
Bengal survey?
Now, the writ contains the entire ground in the writ is failure to act on a representation made under the first but I do not understand the one medical on my I do not understand the first instance. I do not understand it to have made this submission. There was not no opposition for Buddha to take islands. No, if you want to withdraw, they can be it was taken. Yes, I want to withdraw. That's equal to no. File Millard where? Now Millard whatever has the High Court, I don't have a problem again. Now Millard back to the High Court. No, that bench hunting can't
Before the appropriate forum.
Now Millard in this context.
That he doesn't need.
Of course I will. Now let us one submission, Millard. Kindly record Millard our prayer that there is our submission is Millard, there is no power with any authority to demarcate under the Survey Act any private land. At least kindly record that's my submission, So therefore, there is no authority. We can't submit. There is no authority.
Make it submission.
There is no authority which is available to consider this prayer because the writ and the representation on the basis of which the writ has been filed is restricted to exercise of power under the Bengal Survey Act, which has already observed. And after 3 days of hearing, the prayer for withdrawal to approach an authority.
All those are privacy observations only to counter Mr. Mitra.
So they have accepted it. Otherwise,
He may not have accepted.
After this is what the courts have deprecated, at least record a submission that our submission has been that Bengal Survey Act does not clothe or empower any authority to demarcate any private land. That what he wants. Withdrawal of
He wants to withdraw with liberty to file appropriate proceedings before the appropriate forum. Everything is appropriate, not inappropriate. So, are you objecting to that?
He doesn't need that liberty. I'm only on that. If the law provides him with it, he will doesn't need your lordship's blessing.
Especially when they approach
That is submission is not. If he wants to go somewhere, let him go. But what happens is once your
I will record that. If he wants to go, I will record your submission. That if he wants to go, let him go. I will record that. Yes, I will record your
He will
submission.
say that the High Court has given me liberty to come to you. That is something your lordship protects.
Yes, I will also record your submission that if he wants to go anywhere, let him go anywhere.
He is free to go, but
Yes,
doesn't my lord's pleasure.
No, I will record your submission that he is at liberty to go everywhere, wherever he chooses.
Wherever.
Yes, yes, that is what he will decide where to go.
He decides, but not on your lordship's pleasure.
Learned advocate appearing for the petitioner. For the next matter.
Number 5.
I appear to take.
Yes, yes,
So,
sir.
yesterday what I was. He was promoted me yesterday.
Yes, yes, what happened?
The everything.
Yes, yes, what's the progress? What is the instructions, sir?
Also, like this, there are 3 reports you will also wanted.
Yes.
One of the, you have to take one of the first one.
First one is of response number 13.
So 13 after
Which one you want to?
There are 3, here,
Yes, you have filed 3 affidavits.
3 affidavits.
Which affidavit do you want to place first?
The lawsuit kindly takes part of yes.
Partha
Yes.
Yes, yes.
Lawsuit kindly takes one of the.
So, doctor, have you given a copy of this report?
Yes, yes.
Yes.
Already.
Yes.
Advance copy is given.
Yes.
Page 2 lawsuit kindly comes.
Yes.
Paragraph 3.
Yes.
I state that the witness, your lordship may refer to lordship's previous order.
Yes.
Your lordship wanted to have affidavits on the lordship kindly have just because that will lordship kindly will look through your lordship wanted the affidavits to be filed.
Yes. Order dated 14th of January.
Lordship.
Yes.
14th of January, page 3.
Page 3, yes.
Yes.
Partha is
No. That the lordship kindly comes to page 2 at the bottom.
yes, page 2, yes.
Then separate affidavits will be filed by Partha Rai, Robin Khilari, insofar as the allegations are directed against them in the declaration as such affidavit shall be with the handwritten endorsement made in memo number so and so dated 11 June 25 in the document annexed at pages 50 and 52, 50 to 52.
Yes.
And the memo number so and so dated 13 November 2025 annexed at page 3 to 5. Let's say having a file such and such. Then I just place it. Then also after vomiting, yes. And government submits our instruction the license area, Ghatal, highway subdivision, public PWD. The response number 30 is the appropriate authority to file a report with regard to the allegations about enforcement. Then you also wanted an affidavit from 13 of them.
Yes.
Tomorrow 3 affidavits.
Yes. Yes. Yes.
Next one, we affidavit particular.
Yes, Partha yes.
Page 2, paragraph 3.
Yes.
I state that the gentleman endorsement made in memo number 330, 11 June 25, in the documents annexed at pages 50 to 52 of the petition and the memo number November 13, 25, annexed at pages 3 to 5 of the supplementary affidavit, do not belong to this deponent. I have also no knowledge about such handwritten endorsement at all. This is then paragraph 4. The memo number 1461 LA dated 13 November 25 of the Land Acquisition Officer, Posting Medinipur, was in reply to one RTI petition dated 23rd July 2025 of the petition. The handwritten endorsement made on the said memo dated 13 November 25 are all tempered and manufactured with some ulterior purpose, and I have no knowledge about this. One of the same affidavit is of
Robin Khilari.
Yes.
All right. So these are. So he has also denied. He has stated that these do not belong to him.
Yes. And
All
then
right.
one of the 13th affidavit lawsuit.
Yes.
Hurriedly.
Yes.
13th is Pravani. He is the one of the yes. As an engineer, Ghatal highway subdivision.
Yes.
Lawsuit takes one page 2, paragraph 2.
Yes.
I said that plot number, there are 2 disputed plots, 770 and 771.
Yes.
Are not located near the present alignment of Narajal Daspur Road. The said plots are situated alongside another road which is not under the jurisdiction of the Public Works Department. And I am not aware about the authority under whose jurisdiction part of the subject road falls. Then, I have not found any document in the office supporting or relating to the petitioner's alleged claim. I state that the alleged road referred to by the petitioner as Narajal Daspur Road is not the actual alignment of Narazal Daspu Road, which is the Pakka village road. Inside the village, namely Moja Swansu, comprising plot number suggested within this same plot, 77071. Within the police
These are the two plots of the petitioner.
yes, disputed plots.
Yes,
Then,
disputed plots. Yes.
the subject, then paragraph 4, subject road does not fall under the jurisdiction of Public Works Department, even and the same is not maintained by road.
So it's outside the purview of the
Yes.
West Bengal Highways Act.
Yes. Then that also clarified in the next paragraph. I further say that under section 3(1) of chapter 2 of the West Highways Act, the state government may by notification.
Yes.
The official way they declare any road, street, pathway, or land to be highway. Under section 33(2) of the Act, boundaries of the highway may be specified under section 3(3) of the Act. Highway authority may demarcate the boundaries of the highway by placing and maintaining boundary stones or other suitable marks. Then this is very important. The land as claimed by the petitioner does not come with the value of the Act. It's very clear.
Yes.
The one more paragraph I placed there. I just omit then. Kindly text paragraph 8, page 3.
Yes.
The land in question neither falls under the jurisdiction of the West Bengal Highways Act 64, nor under the jurisdiction of the Public Works Department. In their view of the matter, there has been no enforcement upon the land in question of the petition. So this is very clear. Lordship kindly takes the deputation once.
Yes.
The affidavit page 16.
Yes.
Paragraph 1 to 13 are true to my knowledge. But I'll be paying for a trial on evidence. Because these documents are all manufactured for the purpose of the case. And to malign the government officials. And well, there should be a trial on evidence, a big case. Or well, you'll have to be a direct well of the probate to find out the truth. These are all manufactured, tampered. These are not affidavit. Now I'll leave a lawsuit. This has been all manufactured for the purpose of a case. This is unfortunate. This sort of so I want the man who was upon this affidavit let him come to the box. I will process it. I'll make few questions. This trial and evidence is permissible under 226. There are charges lawsuits covered. So let him come to the box. I will
Completely false affidavit. I should kindly see for a
Can
moment.
you file an exception to this?
Yes, yes.
Please take instructions from your,
record it all.
because
It says completely
we have annexed these copies.
Pardon, my lord.
So it comes that it has been manufactured, then your client
Yes,
has
my lord. Then, my lord, I have prayed for either CID or CBI investigation at one.
that I will consider whether CID or CBI.
Yes, my lord.
But
I want to start the investigation by the competent authority.
separate.
Item number 6.
Yes. Yes.
and for the respondent.
Yes.
Last occasion, Lord, wanted to see whether is there any notification towards the authority given to the BLLRO.
Post 3.
Fourth, that is that.
Yes. Post 3 says collector. Collector. Post 3, I think, uses the expression collector.
Yes,
So according to you, that power has been delegated.
yes.
And here
Power has
notice-
been delegated to the DLLRO, and in the instruction of DLLRO, this notice was issued by the BLLRO. Now, Lord, kindly come to, kindly take up Land Reforms Act, section 2(4).
Yes.
Collector means the collector of a district or any other officer appointed by the state government to discharge any of the functions of a collector under this. So if we read 2(4) along with 4(c),
Show me
5,
who has been appointed by the state government to discharge the functions under section 4C. Or you also please, you have an extra
yes,
copy of that.
I always
Copy.
keep one copy.
Yes.
My learned senior. This is not the notification. This is the 14th July 2023, which has not been annexed in the petition, that is regarding illegal filling up
No, I
of
will
water
come to
body.
that. Please show me the authorization first.
Oh.
Because Mr. Banerjee is challenging the very jurisdiction of the person to issue that
But,
notice. Where is that?
I'm not handy with the hard copy, but I have the copy. But
What
I'm,
copy, Mr. Banerjee also? Yes, give me the hard copy.
Yes, I'm already.
But no authorization. Can you see this gate?
The left hand side, West Bengal Estate Acquisition Act. On the right hand side, West Bengal Land Reforms Act. DLLRO is the can act as a collector. That is the circular issued by the governor.
Yes, but here who has issued this notice?
Yes. Now here the BLLRO.
How can the BLO issue the notice?
Kindly take the document which I have handed up.
No, Mr. Thor, if person X has been authorized to perform the
Doctrine of
duty,
delegation.
whether he can again delegate. Show me the authority on that.
Or kindly take this 14 July 2023.
Yes, yes, I'm asking.
Only he has issued on the direction made by 45 is
That is what I am asking you. Suppose by virtue of something authorization has been made to, I am not saying Mr. X, to the holder of post X, whether that holder of post X,
delegation is referring to whether that can be delegated or not. Answer is no.
then you have given the answer, Mr. Dhar. If that is no, then everything goes.
Maintainability.
What maintenance?
As per the L. Chandra Kumar and Mr. Banerjee might have a very good case on merit. But court of first instance and the other statutory tribunals, those kind of a judgment is something else. But court of a first instance, as per L. Chandra Kumar and Ashish Kumar Rai, has to go before the appropriate forum, and that is the tribunal. And that is the tribunal. This exception in respect of Whirlpool.
Mr. Dhar, will it help you? I'm asking. This will only delay the procedure. I will give liberty to Mr. Banerjee to approach the appropriate authority, and I will record this. What is your submission, Mr. Banerjee's submission? Then, if after all that is set aside, again a de novo proceeding has to be initiated, or you propose to rectify.
Once it is entertained, it would be treated as precedent.
Mr. Dhar, that is why I am asking you, what do you want to do now?
For
Do you
that,
want to prolong this?
for that, I'll have to take the instruction.
What I am asking you?
There is no judgment, my lord, of Justice Philip said. Total exclusion and other things, Justice Philip says, observe. You have some problem, kindly observe.
Can you use the microphone, Mr. Banerjee?
Hello,
Ever mobile.
so, not. I can give you a that's it. Because they are really accepting the petitions. No, has the total exclusions. High Court power, a very interesting, my lord, for obvious reasons. They chose the.
Where is the decision of?
Please come the next day. I can.
Only one thing, Mr. Banerjee, because that was on Land Reforms and Tenancy Tribunal Act. After L. Chandra Kumar.
After HON'BLE. With the total exclusions, not. I'll argue my point. And today I'm not this problem. I'll argue on this point, not total exclusion. But only that. So far, this particular tribunal act is concerned, my lord. Language is very peculiar and really interesting because I spent some time, very interesting point, to find out these things. That with the account, even in L. Chandra Kumar, what was the, my lord, point before the L. Chandra Kumar? L. Chandra Kumar case, my lord, 323 A and
Land Reforms and Tenancy Tribunal Act should be এর মধ্যে থাকে তো প্রথমে। Yes, Mr. Banerjee, which section you are trying to refer? Section 8 is the exclusion clause.
That's true, my lord.
Yes.
Once. On and from the date from which the jurisdiction's power and authority become exercisable under this act by the tribunal, the High Court, except when the court exercises jurisdiction or division may carry marked in mind. I'm coming. I know, but L. Chandra Kumar in deciding this case, what was the issue? Whether High Court power under Article 26 can be snatched by incorporating a particular provision in the Constitution of 323.
Subject to correction by you, Mr. Banerjee. L. Chandra Kumar was on Administrative Tribunals Act.
Yeah.
So there was no provision for the High Court interference under Article 220. Tribunal after tribunal, appeal lies to the Supreme Court. That was the scheme of that. On that scheme, it was challenged. That High Court's power under 226 cannot be taken away. I think perhaps section 28 or so in administrative tribunal. I will right.
No.
So on that, it was now the Supreme Court then observed no High Court power under 226. It comes with the basic fact. It cannot be taken away. So the Supreme Court did not declare the statute act as ultra vires.
No.
But read down that provision saying that no 226 will be maintainable or entertainable in what language you may say, but before the division. So, A. Chandrakumar also only preserved the High Court right under Article 226 before the division.
Let me answer.
Thereafter, after that decision was delivered, this tribunal, West Bengal Land Reforms and Tenancy Tribunal Act was enacted.
Let me
I
explain.
think 5-6 months thereafter. That
Let
was
me-
in March, I think in
Let me
November or
explain-
December.
let me explain why.
Let me first.
Oh,
Thereafter,
I see.
so thereafter now, borrowing that observation, preserving the right of the division bench to entertain 226, that provision 6, not 7 and 8 has been incorporated. 8 and 7 gives tribunal the court of first instance. Previously, what happened before 1997 of the International Land Court, what was used to be done? 226 before the single bench. Then intra-court appeal before the division bench. That was not 226. Previously, prior to 1997, was the first instance 226, then inter-court appeal. Now, in the light of this provision, 226 power has been preserved only with the division bench, no further inter-court appeal. Because that's the object. Because this should be the scheme, not again 226 and the inter-court appeal. Mr. Banerjee, I'm conscious of those line of decisions which carves out an exception, saying that even if there is an alternative remedy, efficacious remedy under certain statutes, 226, 227 entertainability cannot be a bar. Under 4 exceptions, some judgments say 3, carved out, some say 4, but all these have been marked into 3 or 4. So I'm conscious of that. But when the statute has been enacted, making providing for a mechanism where the tribunal will be the court of first instance, against that not an appeal, against that 226 before the high division bench. Then whether in such a scenario, whether 226 can be entertained by the single.
Let me answer. After going to the judgment, as they find my judge as well, the issue was whether High Court power can be snatched. That is a core issue. Supreme Court said no, it can't be done. Now, in deciding that, court of law, if the tribunal passed an order, that will be taken care by the division. But not the case. In other cases, High Court power, if you say the High Court power cannot be curtailed or snatched by enacting a particular provision and incorporating that in the constitutions, at the same time, you cannot say High Court cannot entertain. That is not the spirit of the judgment. In that judgment, on the last penultimate paragraph, Supreme Court says, yes, it cannot be done, but against the order of tribunal, division bench only entertain. Instead of single bench. That doesn't mean, my lord, very clear. So, but order passed by the tribunal, that is always to be entertained by the division bench. Does it really mean High Court power under Article 26 is totally excluded? No. Justice, suppose if I file and move an application under 226 for already disposal of the tribunal, High Court can entertain. Why High Court will entertain? And that is entertained by the High Court.
I have reservations.
Well, there is a judgment. Justice said total exclusion is one thing, and no appeal was preferred.
Now,
Then why not refer to the larger bench? Because Justice said point is on that point that if any application is moved before the High Court for early disposal of the matter pending with the tribunal.
I have passed a judgment affirmed by the division bench.
On the same point, I am not aware of this.
And that is on
One thing, my lord.
that is on administrative tribunal act.
No, it is not that.
Because here it's not a case. Mr. Banerjee, there are 2 aspects. One is order of the authorities, order of the tribunal, thereafter High Court, it's one line. Another is inaction. For all these, because you can approach according to you, 226 can be approached for inaction also of the authority.
If that is so, then why not?
There also who? Act says inaction also you have to go to the tribunal. That's the statute. Inaction also.
Well, kindly see,
Not only orders passed by the authorities, inaction.
kindly see section 8, my lord.
Section 8, please kindly come to section 6 first.
Very well.
Any order made by an authority is A, sits against an order. B is an application complaining inaction or culpable negligence. So inaction also before the tribunal of an authority under a specified act, and then appeal, then application. D is very important. Relating to matters under any provision of a specified act. Any application under any provision is wide enough. Or matters relating to any constitutional validity of any act under the provisions of a specified act. There is one distinction. You cannot challenge the virus of this parent act before the tribunal. That cannot be done because that cannot be done. So 1997 Act virus, tribunal cannot entertain, but any other constitutional validity has to be challenged before the tribunal. Inaction, all matters very wide, and that's the court of first instance which has been held in N. Chandra Kumar. Subsequent decision also,
Kindly appreciate your aspect.
and that's the distinction from Sampath Kumar.
My lord, why
That is
ultimately?
why reference to 7 judges.
I know that, but why ultimately kept separately? And ultimately cannot be said.
No, ultra vires from the parent statute, because by that statute, this tribunal was set up. Parent statute only. Other ultravirus, other acts, yes, can be decided by the,
Challenge act,
but not the 1997 parent statute. That's well settled.
No, my lord. Challenge of act is one thing, and challenge of virus of this act.
Virus of the, I'm saying virus of the act.
Virus of the act,
Challenging the virus of this 1997 act cannot be done before the tribunal, except that
why?
challenge.
I'm just asking myself because, and for obvious reasons. My lord, as we know, my lord, whenever the challenge is thrown, there is ultravirus. Three aspects, really two aspects to be taken care of. And number one is violence, Article 14, 19. Now, by judgment, as your lordship set up Article 21, and lack of jurisdiction. So, my lord, that is very vital aspect. Now, if I show a lordship, the person who issued the notice has got no jurisdictions. Jurisdiction is one of the vital aspects, goes to the root of the state. And if that is so, very interesting, my lord. Their concerns. They don't have any jurisdiction, it act doesn't apply. Subsequently, what it did, for the same land, they issued. Can you have a look to this? This is a notice which was Kanishi direct subsequently. They have given to go by their own action and income tax. Who issued the notice? Now, they change it. I will disturb possible. Now, these act not in the schedule. Can you come to section 2?
No, but have you challenged this?
Yes. And that has been squashed.
No, this has been quashed. This is not the challenge in this writ petition.
And be.
No, it is separate writ petition. What I want to show that well. What is actually their intention? Somehow to prevent it. There's no doubt about it. So when they realize these act doesn't apply, they adopted this position because it's a water body. If it is a water body, then that land doesn't apply. And under these act, no question of any appeal or anything.
No, but here you have not challenged this note. Here in this writ petition.
The subsequent act.
Yes. So
and that is
subsequent
I
act,
challenge. But in a different proceeding.
Yes.
226.
That proceeding is a different thing altogether. But here you have challenged the notice under force.
And now, can you see the stand of the person must come with very clean hand and clean mind. They stick to that. No, this is the law to be followed. When contempt was issued and they found they are trapped, their issuance of notice is totally wrong. This particular act doesn't apply because it's order body. How they can justify now by taking all this free appeal and others saying Chandu Kumar, they themselves, sui juga. Now they use the Federal Treasury Act. Then without total jurisdictions, that is so court certainly can do that.
Yes, let them take instructions.
As well as
And you want to cite the judgment of justice state. When do you want?
when the next matter is going.
Then I'll bring few judgments on this point, relying L. Chandra Kumar and Ashish Kumar Rai, several division bench
Judgment based on
I'll-
Chandu Kumar tribunal order.
I'll bring all those.
Against tribunal. Against tribunal.
I never wanted to repeat the same point
Why you are
of
changing
several judgments. And my lord did not allow me to place on merit. I wanted to
Let him-
know what was
On merits, Mr.
Let him
Thor,
cross.
only on that authority.
only.
So if you take instructions, because this will only prolong. Even if I delegate Mr. Banerjee to the tribunal,
Yes.
tribunal, yes.
First
The tribunal
judgment there is
finds
2 years.
that it's without jurisdiction, it will be set aside again. So for that, I'm giving you, please.
That what is bothering me, if my lord is to entertain this
No, my lord, this
restriction,
is lawfully bad. I strictly
Mr.
oppose.
Thor, I'm not saying entertaining is a different thing. That is why I'm adjourning you to take instructions.
Yes.
I've not
That's why-
passed any order on that.
yes, that's why I'm
Now
saying-
for you to take instructions, how you will come back. It's for you. Mr. Dhol, on a senior advocate appearing for the state, raises an objection as to the maintainability of this writ petition. Footstuff, you have a
Similar time is having got a
मला I everybody
yes.
I sorry मला on the particular I was
Yes.
particular the respectful authority claimed the royalty on the issue for production of the brick.
Yes, where is the ability of opposition?
Only thing you can see page 53. This order has been passed.
Page
Page 53.
53.
Second paragraph in the Roman law.
Yes.
In reading of subsection 2A of section 4, it appears. It is not section subsection 2A of section 4 of the West Bengal Land Reforms Act.
Yes.
It is not mentioned in the order, but it was.
Yes, it's land reforms act.
Yes, therefore, this order.
That has been according to him, he has cited a decision that's been declared ultra vires. What do you say to this?
Second issue is royalty.
That is the submission. He has referred to a judgment of AIS Calcutta. For that I have adjourned this.
Even also
Where is Mr. Bandyopadhyay?
also 1972 judgment also declared in that.
There are so many other points are there, whether
What are the other points?
they are opening the state briefly on the right, is true, but we are seeing.
No, but your order, you have passed this order considering certain provisions which have been declared to be ultra virus. How can we proceed with that? The very basis goes. Where is Mr. Bandhavadh? Mr. Bandhavadh is leading you. Where is he? Not today, ask him to come tomorrow. Next week, next Monday. Next week.
Thank for the petition. Ready. But in this matter, Lordship, the private respondent constructed unauthorized construction. Respondent constructed unauthorized construction, Lordship, over the PWD road in front of the petitioner's house. Petitioner's Lordship made representation before the concerned authority.
You are for the
This
private respondents have been served.
Lordship,
When they have received. Yes. Yes, what is your instruction?
Lordship page seeing before the authority, the authority for disposal of the representation.
What steps have you done, sir, for demarcation? It was representation was submitted on June 2025. Today we are in February 2026. What steps have you taken for this long time?
Yes,
You may have received the brief, or your client received it on June 2025. What were they doing?
I have instructed from BLR since BLR has not received the petition.
Which petition? Which petition BLO has not received? Every service? Please check up, please show it to him that the BLO has received.
January Lordship.
Please show it to him.
Item number 9.
The private
Also similar, the
Who is for the state?
Sonship I'm asking for the state respondent and my senior another
much petitioner made a representation, kindly come to page 13 and it's at P2. The backward line of the PWD just beside the road,
PWD road.
yes, yes, PWD,
Yes.
Well, so far allegation of the present petition, I will state that I got information from the private respondent. They are saying that there is no contract.
No encroachment on the.
Yes, yes, that is the allegation.
All right.
And my lord kindly consider, let my learned friend submit some document to show that this allegation previously given to the any competent authority to deal with it. Because I think this representation which he has annexed, my lord, annexed as P2, this is for the first time. First time representation.
First time, but,
of the authority.
second time that is not a different mallet.
Subject to correction, my lord. If there is Paka construction, according to my learned friend.
But the construction is there.
No, no construction upon the road itself.
All right.
Even
Yes,
my
what is your instruction state?
Lordship, I've just received the bill yesterday.
Yes, sir. Yes.
The dispute between the parties is going on in respect of the plot of land that is right
Distributed to private parties.
co-sharers to
Yes.
file for partition. That your lordship finds at page,
Why will come here?
yes. The injunction was there. Now kindly Amar Para Samaran scheme. Now there is a dispute regarding the party there along with the pathway and subject matter of dispute that pertains to this page. In of the plot which is the subject matter of dispute and there is a private plot, tender has been floated for construction of road. Tender has been floated for construction of road, page 43, item number
Over your private property.
Yes. Subject
Where do
matter.
I get this? 43 is very illegible, Mr. Raj.
Yeah, last question. Construction of road from BT Road towards the house of Laltu Sheikh. Baron got it.
Yes.
Now I had approved.
You are allowed to say.
No, it was there. In the parties to the first things.
How do I know that that is the, your Ayati property?
Yes. There is
No plot number has been mentioned here, Mr. Raj.
It is mentioned in such a manner that is why.
Well-
Laltu Sheikh. Madam, the state is not coming forward and say because that is the path. Irrespective of which the construction tender has been floated.
What is your plot?
Plot number, my lord. Page 30.
3416.
Yes.
Where is your record of rights?
Please don't tell me. Injunction application is available.
Mr. Raj, after all, it's for the benefit of the community, Mr. Raj.
Development for the better. Particular house to cater to that pathway. If that is given, then everything will. And how the government can invest the money in the private land. If that is so, I am out of it. If the government scheme can be implemented for the purpose of
Donate the property.
who will do it?
For you claim to be the co-sharer.
That part there is expected from everywhere.
Where is the record of rights?
That
So that it's your Ayati property.
Yes, immediately.
Where is that?
Yes,
Show me some document in your support. Nobody knows. It may be a collusive suit also.
Blood is bleeding entirely, my lord.
Yes, yes.
Yes, yes. Because of it, this mentioned, my lord, in the
Now, where is the plaint, Mr. Raj?
page
Civil Court
21.
order of injunction also states about this assistant engineer.
Yes,
Yes.
that is page 21.
Plaint is page 21. But if you kindly come to the order of injunction, page 31.
SDO
Yes.
complaint was made
For what?
that the construction
That was the subject matter of the injunction application. I also.
subject to measure
That is the recording.
Madam, if you not consider the appearing the plaintiff dependent number such and such, right? to the illegal
Substantiating
construction.
and also produce written complaints addressed to the
Yes.
SDO, Krishnagar assistant engineer. So this
PWD,
construction and other things, who floated this tender?
Panchayat.
Yes.
That is why if but the court has no authority to say that this is you cannot do. Sir, the Panchayat has floated this tender. Tender is not the subject matter of dispute with the civil court.
But why you lodged the complaint? That was the subject matter in the injunction application also you have referred to that.
No, after that. It is specially contained under plaintiff the civil court such and such. Under participants the proceeding inspector having received the copy instant petition before the same. In the present case, the plaintiff approached the civil seeking and police help.
Yes, Mr. Raj, please kindly come to page 34. Oh, this is the subsequent one.
Yes.
Where is the letter of SPO Krishnanago which you produced before the court at the time of injunction application? Yes, on which plots you have floated tender for construction of road? What is the plot question?
Today I have got the plea for instruction.
Yes.
However, my lord, the entire tender document, yet, it's not in a legible manner. I cannot read even a single word.
Yes, Mr. Rai. He is right. I also cannot read anything.
So I try to
You have
find
to
out
give a
that-
better copy, Mr. Rai. Is memo number. You also can get instructions from your client whether on that memo number is
Subject to law correction according to me, my lord. The remedy is under order 39 to me. Because that part has already been, my lord.
you are a party.
No.
You want yourself to be added as a party in the suit.
But in the order, your lordship can see the assistant engineer.
That's the different thing. Can you utilize the Rayati property for the purpose of construction of a road without initiating and proceeding?
My lord, your lordship kindly grant me time to submit a report.
The,
And also
the
the-
petitioner
Number 11. My lord, this has not been completed. Same, my lord, but.
what is this matter?
The matter is that, my lord. Petitioner's father, my lord.
Recording of your name in the record of right. Recording of your name in the record of right.
My lord,
This petition not
my lord,
mentionable, sir.
your lordship kindly see petitioner's father approached before the my lord land tribunal. Land tribunal, my lord, directed my lord by an order dated 2015, my lord, categorically my lord stated that to record his name and complete the mutation case. But after so much persuasion, my lord,
Is the High Court the executing court of the tribunal? So you are making the High Court an executing court of the tribunal.
Well, in the meantime, my lord, the petitioner's father, my lord, died, my lord.
That's
in
a
the year
different thing.
2011.
This approach to the
What?
petitioner has paid for recording, has paid for a direction upon the authorities আচ্ছা একদম উপরে
I am for the
yes, yes, Mr. Mohan.
I have come up. There is a land scam in the district of Jharkhand. Lordship, and look at page 48. Because one of the land belonging to me were sold, registered, everything done. Well, that for that one I court helpless.
So that is PRA.
No, but but there is one another pair because on page 48, you lost your kindly look at page 40. Well, I am only here.
Page 48.
But
Yes.
this is the letter from District Magistrate Jharkhand. Well, this is 30th December. Now, my lord, after getting this letter, and your lordship will kindly look at my lord, paragraph, third paragraph.
Yes.
আপনাকে আশ্বস্ত করা যাচ্ছে যে আপনার ব্যক্তিগত সম্পত্তির সংরক্ষণ ও সুরক্ষার জন্য জেলা প্রশাসন ও পুলিশ প্রশাসন সর্বতভাবে প্রয়োজনীয় ব্যবস্থা গ্রহণ করছে। এ সংক্রান্ত কোনো গুজব বা বিভ্রান্তিতে আতঙ্কিত না হওয়ার জন্য আপনাকে অনুরোধ করেন। ভবিষ্যতে কোনো প্রতিকূল পরিস্থিতি উদ্ভূত হলে জেলা পুলিশ প্রশাসন আপনার পাশে রয়েছে। এবং they have said they are trying to protect my land and interest of the land, interest on it. What is the report about what in what manner they want to protect or will stand by me, because this is the letter 30th December and FIR was lodged in September 2025.
What is the dispute, Mr. Mohan?
The dispute is person claiming himself, I am the Himang Kumar, sold the land, registered, everything. Deed was registered.
You are the owner of certain plots of land.
Yes, that
But certain deeds have been executed
that's right.
in respect of your property.
My and my lord,
Remedy lies elsewhere.
I tell you, let GM, GM is writing this letter.
Later is neither here. Later is only to assure you that they will give you protection.
What
But-
because my lord, your lordship, because when this is not in respect of only one, the entire Muja of the
164 million, 164 disputed land.
164
And that is
disputed.
registered.
Who is the private respondent?
Private respondent, I could not find out their address.
No, Mr. Moso,
They are all fake persons. I inquired in the locality because I will have to make them party. But nothing is there.
no, how do you come to know that your plots have been transferred?
That I have stated, that
No.
and I have
You have got any document
yes, certificate.
from the registration of it?
Yes.
So from there you will be getting the name of the
But
person.
the person who has purchased the property and the person who has sold the property, but none is available. Showing me dead, they have produced some document, and it has been. Well, I was looking at I got a judgment of Tamil Nadu Madras High Court. Division bench judgment regarding this registration. There is a provision. Registering authority can go for summary
Yes,
proceeding.
when the a document is produced before the registration authorities, it's the duty of the registration authorities to vouch that.
And
But dispute only with regard to that, the executed come, whether have you transferred some question, the registration authorities put to the executant and who presents the document for
And
registration.
here, Nothing, but I don't know, that has been done, must be. That procedure has been, that, your lordship, we are all
But,
aware. These are, but I am
But
only
now,
on this way.
here
Your
what can
lordship,
be done?
this is what I tell you, lordship. So that if your lordship kindly direct the DM to submit a report before lordship, what is the
Oh.
way they are thinking to
Sir,
protect.
Mohit,
Otherwise,
that's,
your lordship can see. There are at least for 170 persons or 63, 164. Well, 164 persons. Now, one of these persons, these persons are of the same locality, more or less same moja, within the same police station. Police station in Shakrai.
Charge sheet has been submitted.
But that is one aspect.
only one thing, Mr. Mohit, please come to the first paragraph.
My
First paragraph of page 48.
page
The
40.
document which you have
Yes.
First paragraph, it says, আপনার দাখিলকৃত অভিযোগের পরিপ্রেক্ষিতে জানানো যাচ্ছে যে সাকরাই ব্লকের অন্তর্গত মৌজা বাঁকড়ায় অবস্থিত আপনার ভূমি সম্পত্তি সরকারি নথিতে পট্টা যথাযথভাবে আপনার নামেই লিপিবদ্ধ রয়েছে। So the copy of the record of rights has also been forwarded to you. So according to the DM, so it still has been recorded in your name.
No,
So no right of yours has yet been affected. Now, the prayer which you have made for declaration, for that you have to take other steps. So till now you are in possession. You are in possession. Record of rights also stands in your name. So none of your rights have been affected. The rights which have been affected is some forged deeds has been created. For that remedy lies elsewhere. You have to approach that authority.
That will be when I tell your lordship that is.
And somebody
Time-consuming matter, number one.
Sir,
Your
so
lordship,
it cannot be cancelled from here.
If my lordship will kindly give a second thought. If my lord, this is a scam, like my lord, land scam or whatever scam we may call it. Because it has been done by some person and my administration has identified or has taken some steps. Some persons have been arrested. I have been informed.
Steps have been taken.
Yes.
What steps have been taken?
Some persons have been arrested.
Arrests have been made, Milord. Though I have seen
Already arrested.
persons have been arrested, charge sheet has been submitted, Milord. But from
Now,
the
by
end of the
this,
police-
my lord, their deed will not stand. Number one. Number one, DM has, I have just made one prayer. Direction upon the district magistrate and collector to appropriate steps for protecting the interest right title over the property.
Yes, that has been done.
Yes.
The application of 30th December.
Yes, they have been done. Some cases have also been registered.
Yes.
Cases have also been registered.
Yes, but
So-
by that, my lord, that right of the purchaser doesn't go. But
Right of the purchaser will not go. For that you have to, they cannot also cancel this. Even if the proceeding is
district register can call them and go for further verification, whether it can be done or not.
Mr. Moisto, that will be difficult. When the registration has been done, whether the after registration, the registrars having authority, please show me the provisions on the subject to correction by you. There is no provision after that registration has been made. Under what provision? Because the authorities have to act only as per these provisions. Please show me the provisions after
I have
registration.
seen, madam, Tamil Nadu Registration Act was amended to that extent after getting some cases regarding that. And then, madam, Tamil Nadu government, the India.
Now here, it has not been such similar provisions
No,
have not been made.
I didn't find.
So if that is not so, in the writ court it may be difficult.
No, but there,
But
it
you
can
will
be
be
said.
getting a comprehensive relief before the civil court. Because,
No,
Mr. Moisto, I am telling you, to prevent this multiplicity of proceedings, to prevent
Well,
this
difficult,
transfer.
I was explaining that. Well, it is registered today in the name of X. On this very same day, X has registered in the name of Y. After a few days, Y has registered in the name of Z.
Multiple transfers will be made.
Before to.
But
We,
Mr. Moito, if you're right,
my lord,
the initial transfer, the first transfer
First.
from you
yes,
in favor of X or Y, whatever it might be, the
If it
initial
stands,
transfer, if that is set aside, that can be done only by the civil court. And if your right is protected, all subsequent transfers will go.
that's
They
what-
will not acquire. Maybe they may create some post
Problem.
document, but your title will not be
At
affected.
least, my lord, may I pray one thing before your lordship? That, my lord, if, my lord, some untoward incidents happened for taking over the position forcibly, I tell my lord, only this protection, at least, my lord, DA should, my lord, protect to that extent till the matters are finally decided by appropriate authority.
I can direct the local police station to take, once you approach to take steps in accordance with law. Because DA, Mr. Moitso, he is staying far away. Because only the local
No, no,
police
no.
station is the appropriate
the
authority
local
whom
police-
you can approach.
I definitely, my lord, but when your lordship kindly, if your lordship bind the DM, if your lordship
If you approach
he
the
will-
DM,
he
DM will write to the SP,
No.
SP to the OC.
No,
So it
madam,
will
this-
be a time consuming matter.
I tell your lordship, I will certainly, my lord, at the very initial stage, I will rush to local police station. But my lord,
But before that,
Sometime-
you have to approach to protect your title and possession also. Because Mr. Moito, one thing, somebody's name, somebody has a registered deed now in respect of your property.
Yes, yes.
He may come, they may approach the police station saying, look, I also have a registered. That is why, so you have to first approach the civil court, get an order of injunction that can be implemented. Otherwise, when the police authorities, that is why I'm telling you, when two registered deeds, you will be showing a registered deed, record of rights in your name. Another person will come with a registered deed for the sale. So what the police authorities will do, whose possession they will protect,
No,
they cannot
my
take any
position is still now with us.
but they cannot
To that,
decide.
my lord, at least
Mr. Moito, they
administration
cannot
has
decide. They cannot decide on the possession. That's the difficulty. Then they will say same thing. Civil dispute. Please go to the court.
But
So I can say only if you approach, they will render all possible assistance. And in the meantime, you please approach the appropriate forum. And pursuant to this, I take this on record, stating that these steps. Please give a copy to Mr. Moitro. What steps have you taken? Because various deed numbers are there. This may be relevant for you to, if you think of approaching the civil court with regard to this.
Possibly this report will help him.
Yes, yes. Because various reference of various deeds are there.
And says that large scale fraud has been.
all documents sent to the Vidhannagar Cyber Police. Then only they arrested.
So two PS cases have been registered. One is 110, one is 116.
Sakrail may not, yes, case number.
Sakrail is 116.
Yes.
No, Sakrail there are two cases. One is 110 of 2025 and another is 100.
117 of 9/10/2025.
No. In this report, two cases.
Yes.
There are several repetitions.
Yes, in item number
12 to 15.
In item number 15, my report displays three cases. All of Sakrail. First one is 1110 of 2015.
All these concerns the same plot.
Same area. Same
Same area.
Same mode.
1110, 116 and 117.
This is already taken in action. Now, you have to see, there are. That, yeah, here I don't say, but authority has not yet taken any action, but taken some. But difficulty, suppose, I will make the party X and address mentioned there. And my difficulty is, if it will be written, nobody is there. Locally, we have inquired everything up to adjacent areas also. Because I know this area very well, because from here I was elected long back. That's why there is a connection. That's why I know the area very well. This is adjacent area also they inquired. I told them that they have already inquired and they told them no. They are not residing anywhere. None is residing there. None person is available. And when they have been identified, they have been, and it has been registered. And generally, my lord, there's unless there is some link connection, it could not have happened. And when there is one a large commercial.
Deed writer, identifier, everybody. So
Test.
identify deed writer also.
I did that.
Every against all of them, this they are proceeding.
More or less the same
Investigation is-
did writer, but
Maybe so.
there might be 1 or 2, 3 persons.
The petitioner claims to দেখে নেবেন ওইগুলো
My number is same, my lord. Same.
11, 12,
13, 14, 15.
up to 15 ও 12, 13, 14, 15 এই চারটে শুধু একটু এই রিপোর্ট গুলো থেকে ইয়েস কেস নাম্বার গুলো দেখে নেবেন আর অ্যাডভোকেটের অ্যাপিয়ারেন্স গুলো দেখে নেবেন আমি আপনার ফাইল Yes,
Or I'm for the petition. This graduation.
yes, who is for the state? Yes, what is the,
Or in short, my lord, my section 10(4) appeal has been disposed of by the responding authority.
you have been held to an encroacher?
No, not only that, without giving me sufficient opportunity of hearing, I tell you what has happened. The background
You
is.
are appealing? Yes. Yes,
What has happened is, my lord, a writ petition was filed wherein it was complained that I am an encroacher. Pursuant to the order passed by this honorable court, a proceeding was initiated under section 10(1). 10(1) proceeding was initiated by Assistant Engineer Korakpur Subdivision. He has no jurisdiction to initiate the said proceeding. Now, while demarcation was done, no notice was served upon me. Thereafter, 10(3) order was passed. 10(3) order, my lord, it has gone against me. I prepared for the writ petition against the 10(3) order passed against me before this Honorable High Court. Honorable High Court has said that since this is an appealable order, I have to go back before the appellate forum and liberty was granted to me. I appeal. But that order was passed by this Honorable High Court on 8/8/25. Now,
yes,
I, pursuant to the grant of leave given by the Honorable High Court, I preferred an appeal before the authority concerned. The appeal was filed on 27/8/2025. My lord, no notice for hearing was immediately given to me. Thereafter, I filed an application for expeditious hearing. Pursuant to my application, a notice for hearing was given on 9/9/25 for fixing hearing on 16/9/25. On 16/9/25, I appeared for hearing. No hearing took place. Thereafter, my lord, we also have given out.
no hearing took place, meaning thereby?
There was no hearing at all because the authority concerned who had to give a hearing was engaged in some other matter, being SIR related matters. Therefore, no hearing took place on that very particular day. Thereafter, we further received a notice on 15/12/25, fixing the next date of hearing on 23/12/2025. On 21/12/2025 midnight, my Jethima passed away. On
So you could not attend on 23rd?
On 23rd, I have given them an adjournment notice also, an adjournment application also, that they received also. If your lordship kindly sees,
So according to you, without hearing, an
without
order has
hearing
been
me, the order has been passed. Therefore, now, lordship, only two things. The order was passed by Honorable High Court on 8/8/25, directing them to dispose it of within 4 weeks time. That they have not done. I filed an application for expeditious hearing. That was not considered. Now, the first hearing was fixed on 9/9/25, that is more than after 4 weeks. It was not taken up for hearing. Thereafter, one of the hearing was fixed on 23/12/25. I prayed for an adjournment for a day's time. That was not granted. Thereafter, after 22 days, they have issued the order. So therefore, my lord, they could have given me one chance to present my case.
Yes, Mr. Dev, what do you say?
I can't say anything, but only thing here, he is saying that he has prayed for time, nothing on it.
Yes, yes. I will show to your lordship. Lordship kindly comes to
And he
pay.
has submitted the written submission.
Sir,
No, hearing, one must get opportunity.
Lordship kindly
yes,
come.
one must get an opportunity. Where is that? Mr.
Page
Dev?
91. Page 91. Lordship kindly see page 91, and at the bottom is the seal with the time.
23rd, Mr. Dev,
Yes,
there's a receipt.
I cannot.
And the other thing is, Mr. Dev, the copy of the report and other documents also has to be furnished to them. Otherwise,
That he is happening from the first round of this petition.
yes, have you
All are with
supplied
them.
to them?
All are with
If
them.
you have not supplied, Mr. Dev, hearing has to be an effective one.
Yes,
So it has civil consequences. Because removal, anything, so very basis is your demarcation report.
Everybody is there. She's very insistent on he has got.
So unless you start,
asking my lord as to whether he has got on that.
And also report submitted
he
in.
said that you have no, that is why I'm asking.
Yes,
Yes, Mr.
or
Dev.
my
On the Path appear, you have submitted report to the position of court in
Or-
earlier occasion.
or my
Who appeared?
Mr. Samito Bandyopadhyay in earlier petition.
So report has been supplied.
Yes,
or
yes.
my,
Mr.
my
Dev.
instructions, we don't have the demarcation report. I will be grateful to my learned senior friend if a demarcation report
Alright.
is given.
No issues, Mr. Dev.
You are
Please.
ask the officer concerned, my lord.
Very well. I will ask the officer first.
No. He said,
Why?
when can you bring, can you get the copy of the demarcation report? So
No.
here and now, it can be done.
Disposed of.
Yes.
Matter will dispose.
Yes, I will dispose of this matter. I will fix a time limit.
No, today your lordship can dispose of and directing the demarcation.
Yes. To hand over the demarcation report to him within a certain time, please. And can you give me a date? On that date, I will fix. No notice,
I will
nothing.
not say, my lord, if I say, sir, your lordship will say, courts are not true.
Mr. They please give a date so that otherwise you will have to give notice to both of them. Again, one will come and say, no, only one day before I have got a notice. For that, I am asking you, please give a date and time.
Our commission.
Here, no question was asked.
No. Now the fresh hearing has to be held.
Yes,
Well, Mr. Dev, please give me a date. Please give me a date. Please suggest a date, Mr. Dev, because
If I
because
suggest your lordship will record because they suggest.
yes, they will agree. I will record that.
No, February says it.
That liberty I am giving it to you. You fix the date. Because officers are under your control, Mr. Dev.
March any day. Any day. Because I have no.
Please suggest a date and time. What will be the convenient time?
11th of March.
What time? 12 or 2? 2 p.m. Yes, Mr. Dev.
Yes, Lord, I will abide by whatever lordship directs.
And how soon can you serve the copy of the report?
Without discussion, can I say, achieve your lordship? The lordship directs, they will supply.
Again, he will come. I went to the office. Nobody was there.
No.
That is why
He
I
will
was
the copy of the order and ask for.
who will supply. Because now the records are before the DA. All records are before the DA. Then
DLR cannot. Can you direct the DM?
DM will
DM will do.
all are with him.
If required, he will collect.
can you bring the report here, Mr. Dev? I think that will be better. To end all things. I think that is better. I'm fixing a date. Please bring that copy of the report.
Direct the DLR to supply the report.
Whether I do not know after that demarcation whether the
He returned, he or
he returned.
Yes, sir.
Then I will direct PLO to supply him a copy.
Yes, concern DLR.
And only one thing, let all the points be kept open and be considered.
Only point which
What other points of objection, Mr. Dev, you have? This is one objection. What other points of objection?
On merit, there are many points.
What
I tell you, Doctor, the first point is that the person who has initiated the proceeding under section 10(1), he lacks jurisdiction.
Why?
Because, Lordship, this particular road, if your Lordship kindly comes to page 22,
Yes.
this road is under Kharagpur division.
Yes.
Kindly come to page 22.
Yes.
Now, Lordship kindly sees the Kharagpur division PWD. The serial number 4 is this concerned road, Pontai Belda road.
Yes.
Now, Lordship kindly turns to
So notice issued by which division?
notice has been issued by other division, another division, not Kharagpur division.
Why did not take this point?
We have taken all these points. All these.
point was
When you preferred as the read petition, why you did not take this point?
No,
This was the best point.
and
for you.
we have taken
Without jurisdiction, appeal also did not be gone into.
or we have taken this point.
You are not there at that
I was
point.
not there. I was not there, but we have taken this point,
this point.
and all these points have been kept open and remanded back. And there are other points also.
This was heard by the SDU.
But if the initiation is wrong, Mr. Dev.
No, if the notice is given by assistant engineer of the concerned
But
area,
not within his jurisdiction. He's challenging the jurisdiction.
where from he
So-
get
No, that is on merit side. I'm not right. Because he is giving this page 22.
yes,
He is saying the name of the road is Kontai Belda Road.
yes,
that falls within the Kharagpur division PWD.
Yes.
And
where
according
is
to
notice?
him,
Where
the
is that notice? He is challenging.
where is that notice? Is issued by which?
Yes, yes, I will show to you.
I think Mr. They must have, Mr. Dujoni Day. They must have seen
Kindly come
that
to page 25, 26, and 27.
25, which authority has given?
Assistant Engineer PWD Kharagpur Subdivision.
Yes,
And this Kharagpur subdivision is under, this Kharagpur subdivision is not, is under Bindapur division, not under Kharagpur division. If your lordship kindly comes to page 31.
31.
Yes, we made a RTI application. Under which division does Kharagpur subdivision lies? The answer is it lies under Bindapur division.
Yes. Mr. Dey, please check up. Then the Mr. Dey, the entire process has to go.
No, kindly. Subdivision are.
Kharagpur subdivision falls within Midnapur division,
Yes.
but not within Kharagpur division. This road falls within Kharagpur division, Kontai Belda road, not Midnapur highway division.
Kharagpur subdivision.
Yes.
Then in that even I'll take.
Please take instruction. Then I think no useful purpose. Again that,
No,
again
this
remand.
challenge was made. Kindly come to page 41.
Yes.
Earlier repetition.
Yes. What happened to that?
Page
Any
35.
decision on that?
Yes, yes, lordship, it has been remanded back with all points kept open.
Both countries.
Yes. But
Wait.
both of you are Mr. Dey. That's the difficulty.
He is senior then, I am junior.
No, certainly not.
Yes.
Page 35 is the order.
35.
Yes.
Yes.
And the points taken. First, second, 36, first, second, and third.
Yes. 36. Page 36.
Bottom, second, it has been challenged by the petitioner that. And my lord, third one is at page 37 top. SDO has.
Yes.
Now kindly come to the finding.
Yes.
Findings follow. At page 41.
Yes.
Moreover, though the point of jurisdiction of the authority concerned has never been pleaded by the petitioner, but during course of hearing before this court, the respondent authority submitted necessary GO, where SDO has already been notified by the government while its notification date.
It's not a question of SDO, it's a question of initiation by the engineer concerned, executive
I
engineer.
was reading, I have not complete. As well as the notification for declaring the authority of the Public Works Department concerned under West Bengal Highways Act 1964 has been properly.
All right. Let the appellate authority decide all points.
And lordship kindly sees the next para. The
All
part
right,
was
sir. Let the
initiated, that has
appellate
been kept
authority. I will give you liberty to raise all points because the jurisdictional point can be decided by the appellate authority. It's the best person on fact.
Yes.
Because after bifurcation, what happened under which division, what's the date of bifurcation, all these factual aspects are to be gone into. I'm not deciding the appeal. Yes. Yes. Yes, yes. Yes, what is this matter? You are for the petitioner. Yes, what is this matter?
Matter is to unauthorized construction by law. The
Yes.
instead of interest claim of the petitioner purchased a plot of land.
Yes.
Thereafter, he found that a private respondent is running a stall over there. Accordingly, he made an agreement that if you temporarily shift and let the construct, I will hand you over a shop, permanent shop. Along with, I will for compensation, I will give you 50,000 rupees. Accordingly, the
Agreement between whom?
predecessor in interest and the private respondent.
Your predecessor and the private respondent. Yes.
He has passed away by meanwhile and at present to the petitioner's survey. Now what happened after the petitioners handed over the possession back in 2022? Now what the private respondent did, he made a permanent structure with iron post and tin shed in the front portion of in the over the road, covering the entire front portion of the building. Now the aggression and interest of the petitioners has totally been restrained. Now when the petitioners went to object the illegal construction, he even assaulted the old age mother, the petitioner number one, and the petition and other petitioners. Accordingly, FIR was lodged. The petitioners accordingly made representations before the respondent authority, but unfortunately, neither the representations has been considered nor any steps has been.
When the representation was submitted?
Well, 6-1. Well, it's page 54 onwards, and it's a page 6. And my lord, page 49 and 50 is the photographs of the unauthorized construction. Kindly see the entire portion has been covered. My lord, page 51 is the FIR lodged by us.
No, this is the deed. This is the deed of, where is that agreement?
My lord, that settlement agreement.
Yes.
My lord, and just at page 28, annex to P.
Yes, you have agreed to this, that we will construct the tea
That-
stall
my
on the
lord,
pit of.
That stall was shifted from the near stall over four cycle wheels tea stall. That was shifted from the land of the petitioner to the roadside. But now what happened? Kindly see.
Yes.
Kindly come to page 49. This entire structure has been constructed.
Yes, আসুন। The petitioner alleges Yes, yes, yes.
On the point of in the last occasion, your lordship was rich enough to accommodate this my lordship.
Yes, yes.
Yes, yes. Because we classified the court my lord to bring some judgment.
Yes, yes.
We need only
Judgments are here. Yes, please make your submission.
my lord.
Yes.
Before my lord, only more days time, my lord.
No 2 more days. Yes, where is the senior? Yes, where is the? You are here. Please start. Yes. What is this matter?
May I submit all the points to make?
Yes.
My lord, so far as my lord, before my lord coming into the my lord calculation, my lord lordship my lord knows the tribunal under article 3 should be. My lord kindly takes trouble my lord to refer to my lord the section 8 of the document.
West Bengal Land Reforms and Tenancy Tribunal Act, the exclusion of jurisdiction.
My lord, I just want to point out one thing. Lordship has a yes.
Yes.
Lordship will kindly have a look at that. I'll just place it first. On and from the date from which the jurisdiction, power, and authority become exercisable under this act by the tribunal, the High Court accepts whether court exercises great jurisdiction under Articles 26 and 27 of the Constitution by a division bench, or any civil court, except the Supreme Court, shall not entertain any proceeding or application or exercise any jurisdiction, power, or authority in relation to adjudication or trial of disputes or kindly notes application relating to land reforms or any matter connected therewith or incidental therewith. I or any I pause here for a moment, my lord. The various ors which have been used, my lord, these are disjunctions, my lord, categorizing each and individual category which are all under the aegis of the section 8. Now, my lord, this my lord particular my lord, this is my lord the under the this is under the my lord, rules 290, 220, 222 and 223 of the West Bengal Land Reforms Manual. Now, my lord, that fell from your lordship on the other day, my lord, that since it is not under the rules but the manual, then how it shall apply and why should that be considered? Now, my lord, the answer to my understanding is my lord at section 8. Because my lord, specified act or any other matter under any provision of a specified act is one category. My lord, the other category is application relating to land reforms or any matter connected there or incidental. But it is my respectful submission, my lord, the land reform manual will be covered under this particular part of the section.
Show me the land reforms manual.
Yes. And my lord, yes. This is the land reforms manual. And my lord, rule 3, clause or rule 3 of thereof, my lord. 3. 3, my lord, is this manual lays down. My lord, I start with 2, my lord. It is a comprehensive manual and covers more or less the whole spectrum of activities of officials and functionaries at various levels of land and land reforms administration in West Bengal. 3. 1. This manual lays down principles and procedures to be followed by officials and functionaries in matter relating to land and land reforms, kindly mark, in accordance with the provisions of the relevant acts and rules made thereunder. It also embodies government policy in matters relating to management, use and settlement of government land, and also in matters relating to Shoirati interest in such land. Now, the provisions of the orders, notifications, manuals of the state of West Bengal, state government, or of the Board of Revenue West Bengal, which were in force immediately before commencement of this manual, shall stand repealed. The extent they are repugnant to or inconsistent with the provisions of this manual. Now, in conjunction of this, this is governing the matters of land reforms and section 8 of the Act of the Tenancy Tribunal Act. It has various categories. One of the category is the specified act. That is squarely directly covered. But the other category, this particular words or applications relating to land reforms or any matter connected therewith or incidental thereto, would pertain to matters which covers the issuance of the renewal of the long-term lease. Now, this memo of 20th September 2029 kindly has a look at P2 of the writ petition, page 21.
Page 21, yes.
My lord, kindly, this is for a sanction, but I'm just pointing out the relevant part. Only, but 4 lines from bottom. For a period of 30 years with effect from 22nd January 88, that is the date of occupation of the land by the lessee subject to realization of the salami in full and all area dues in terms of rules 219, 220, 22 and 23 of the West Bengal Land Reforms Manual. So, my lord, when my lord, I read this together with my lord, the section 8 and my lord, the purport of the Land Reforms Manual, well, this is in connection with all matters relating to land reforms, even going beyond the specified act. That is a separate category under the section 8 of the Tenancy Tribunal. So, my lord, it is my respect to submission. They can, my lord, this matter should be, my lord, decided before the tribunal. And, my lord, some because section 8, my lord, gives disjunctions, not conjunctions. Each and every are separate categories. If the matter falls under any of the categories concerned, then, my lord, it is a matter of the land reforms. And, my lord, it should be decided by the tribunal.
Yes, what are the decisions you are
Yes,
referring
my
to?
lord, the decisions are, my lord, this is Howrah Trading report.
It is Justice Mukherjee. Where is that?
So this is 2014.
Justice Subra Kamal Mukherjee is preparing judgment. You have not brought that. Because that is against you. For that you have not brought.
But I have not come. I may be.
You have not come
I have not
across.
that particular. I have not come.
Yes.
But I can come back with that. But I satisfy you lots on that.
Yes.
This is, my lord, Howrah Trading Corporation. This is 2014 SSC Online, Calcutta, 11223.
Yes.
Lord, the first paragraph, my lord, the issue has been, my lord, the premise of this judge. A plea has been taken at the instance of the respondent that the single bench of this court should not entertain the writ petition.
Which paragraph?
My lord, the very first paragraph.
No, though an innocuous prayer is made.
Yes, yes. No, I'm sorry. Though an innocuous prayer is made in this writ petition for a direction upon the concerned authority to dispose of the representation made for early disposal of the proceedings initiated under the provisions of the West Bengal Land Reforms Act, a plea has been taken at the instance of the respondents that the single bench of this court should not entertain the writ petition under Article 226 of the Constitution of India. So, my lord, the judgment, my lord, thereon, my lord, proceeds to quote, my lord, the section 6, section 7, and my lord, section 8, etc. My lord, then I'm just pointing out one of the relevant portion. My lord, then, my lord, the my lord, L. Chandrakumar has been, my lord, quoted at page 4 of the report. My lord, the page would be, my lord, apparent on the very top. My lord, there is no paragraph marking in this.
Yes, yes.
Fairly at the, my lord, starts, my lord, quoting, my lord, L. Chandrakumar, paragraph 99. What is the scope and ambit of the power of the tribunal under 323 capital A and 323 capital B? And, my lord, that they have the power to decide.
Paragraph 19 of that petition has been quoted.
Yes, yes. 99.
99, yes.
Yes. And, my lord, I skip on to the
98
last
and 99 are the two relevant paragraphs of that petition.
Fine, I'm great.
Yes.
My lord, I proceed to the last page. My lord, it goes on to, my lord, the last page, my lord, one. My lord, the first paragraph which is there, my lord, last 4 lines are right. Even the Constitution bench has held that the action of the authorities under specified act is capable of being assailed before the High Court under Articles 227 and 227, but after exhausting the remedy before the tribunal constituted under Articles 323 capital A and 323 capital B of the Constitution. This court therefore does not concur with the submission of the petitioner that petition before the single bench is maintainable for inaction and a writ petition was dismissed.
No, but it is generally that's well settled. But now is with regard to the land reforms manual, because there are direct authorities on land reforms manual. Where are those?
My lord,
The first decision is of Justice Mukherjee.
no, then, my lord, give me a chance to come back with those. I'll apprise the lordship police.
Any other decision you are
My
having?
lord, I have this Indian Oil Corporation versus Kanchit Agarwal of Justice Mukherjee's panel.
Yes, this
Division
that.
Yes. Yes. Indian Oil Corporation versus Anshit Agarwal and others. Mat number 1212 of 2021. Judgment on 7th of.
This is on land reforms manual.
My lord, this is on, my lord, spectrum of issues, my lord. This is
No, I am specifically on land reforms manual.
specifically, my lord, because
On land reforms manual, there are decisions.
section 8 is scope and ambit of the tribunal.
With regard to land reforms manual, there are specific decisions passed by Justice Banerjee also. I thought you will be relying upon that decision. It's in 2023.
My lord, lordship is referring to the Abdul Hudud judgment.
Yes, that's on land reforms manual. So here the issues with regard to land reforms manual.
Yes.
Where is that?
My lord, it is, my lord, if comments to your lordship, I'll come back. He gives any other day, my lord, I'll come back. But my understanding, so far as my understanding goes, my lord, the land reform manual will also be covered because of the section 8.
Now we are only concerned with land reforms manual. Section 8, 9, those are well set. So that's neither here nor there, but it's only because the first decision said no, matters connected with the land reform manual, it is maintainable. That's also by a division bench.
Yes.
So considering all these, considering the Land Reforms and Tenancy Tribunal Act,
Right.
so when there is a direct authority on that point, we have to consider that, and that's by the division bench, binding upon me.
Abdul Hudud judgment.
No,
And
no,
my lord,
prior to that is the Justice Mukherjee's judgment is of, I think,
right, fine.
Bandharda Bill Matsyajivi Samobai Samiti. It's 2014 1 CLT 258. That deals with the manual. Yes. Where is Mr. Rai?
My lord, kindly allow us one day time, my lord.
Ask him to come at
But
2
the
p.m.
other judgments are also there. My lordship is giving it at 2.
Yes, yes.
My lord, I can come back with my lord Justice Mukherjee's judgment.
I've got Justice Mukherjee's judgment. I've got Justice Banerjee's
I'll
judgment.
come.
You can, during your research, you can work out for that. 2013, you have the SSC online.
Yes, yes, I'll find.
2013 SSC online Cal 22684. That's the parent judgment on land reforms manual. Next is Justice Banerjee's judgment 2023 SSC online Cal 405. And there is also another division bench judgment because this has taken a different view, holding that Justice Mukherjee's judgment is par incurium. But there's a subsequent judgment which has relied upon Justice Mukherjee's judgment.
Yes. But it is,
Where is that?
my lord, kindly keep it tomorrow. I'll come back. Because otherwise, my lord, I'll be, my lord, apprising, my lord, let me have a chance.
Please come at 2 p.m.
Well,
Mr.
Mr. Rai will be there.
Ask him to come at 2 p.m. Yes. For the next matter.
That matter,
Which matter?
state updates was updated, submit a report was showing that the award has already been communicated to me.
Yes.
And Maladan, please direct me to call upon the state respondent,
Yes, yes.
Madam, call them, madam. They are both of them are ill, madam. They will be available from next Wednesday. Yes.
Mr. They keep appearing in this matter.
They are having the
Repeated
report.
occasions cannot be adjourned.
They have been with the report handed.
None appears for the Yes.
Yesterday, my lord, I submitted the deed list of dates. Today, my lord, I will go to your lordship the document next to the condition.
That matter, yesterday is better. Let's come at 2 p.m. After that matter. আর কিছু নেই তো monthly matters upgraded
Yes,
matter.
sir.
After that I will
Yes,
check.
sir. Yes, sir.
item number 196. Yes, yes, yes. There are two matters after the character. Yes.
relating to physical construction on the PWD road.
Yes.
Page number 39.
You have served the private respondent
Private respondent matter case.
when they have received. When they have received. Yes.
September 6th.
Deputy You are appealing for this. Where is the petitioner?
Line for the petition.
Yes, same matter.
Representation date to be rectified. 27, page number 27.
এখানে না Yes.
Whether now so far as the justice common authorities judgment, it is in favor of us, but this is all other matter the judgment is relating to 49 settlement. Now our matter is it is not under 49 settlement and the authority is different. Now I want to see only 2 days time for preparation. Kindly give us 2 days time. Make one submission because the initially was we let us fight the notes. It will be better, but I'll cover all the judgments. But give us some time, or we because otherwise, what will be better? I only this issue. I also handed over a judgment which is against us, passed by the original. Can you allow us try to one or two days? 2 days is very short.
Settlement, this is with regard to the land reform, all matters connected, how it is.
I believe what this law is now, this is a not if settlement is not under 49.
Settlement under what provision?
Special kindly consider the least. Here the authority of the assistant engineer.
Under what provision of a statute? Please tell me that. This settlement may be by whatever authority, under what provision? Under what provision this settlement is being made?
Well, this was for the encouraging small business under some.
Under what provision of law? This settlement.
Let the state file a report,
I am asking you, you have filed a writ petition. State,
yes,
you have to allege under what provision of law?
Because of 49 settlement kindly consider who is the and kindly consider my
Yes.
Page 16 lawship.
Page
16 is the lawship, the renewal history.
Yes. Yes.
And lawship page 21. The page 21 lawship. It is the after expiry of the list.
Yes.
I paid for lawship extension. Thereafter lawship this memorandum was issued by the concerned assistant secretary.
Of which department?
Land and Land Department.
So under what authority they will act? Annual PC Rule 3. All settlement, any settlement, land reform. Is the matter connected with land and land reform? All matters what settlement?
But the authority should be lawship as per section 49. But the authority is different.
Maybe even if it is not 49, it is within the manual.
Allow us to sometime lawship if we can develop our case. Otherwise, lawship.
Who will develop? Who will develop the case?
If we can find out some judge.
Who are we? We, expression we, who are included within we? Anyone leading you?
No, members of the bar, we are the members.
No, the answer he has given. On the prayer of yes, sir. Yes.
Note that this update I have been out yesterday. And Lord, I have also recorded Lord the several pages of this petition. But today, Lord, I want to place some of the pages which are very well relevant for our Lord, your Lordship may recall that since 2012 they have Lord initiated the proceeding before the Honorable Court filed several petitions only to outstream. Nothing else. Because Lord, they have constructed their Lord hotel and before that, we have the plots, we purchased that plot, Lord, for the purpose of that, showing this that is was acquisition by the government, Lord, they are
Time to outstanding. Since 2012. My lord, first page note I am laying note at page 34 of my requisition.
Yes.
Page 34. Before that note, I did not do. Page 34, your lordship kindly available. Page 34, this is the second disposition. Third disposition.
Yes.
It has so and so, and an advocate for the state is right in contention that this disposition has been essentially presented. A review of this bench order dated so and so, passed in so and so on the authority of a coordinate bench of this court dated so and so, passed in so and so. Since the earlier disposition of the fiction of so and so has been dismissed on the immediate disposition lies in preferring a writ appeal against such order. So before this disposition of 2015, there are other two resolutions. Next, Milord, in terms of this order, probably Milord, they have advised not to file paper appeal. Milord, the appeal at page Milord 40. The order starts at page 40. The 11th page Milord at page Milord 43. Anyhow, there was no Milord, the division bench of this honorable court Milord has said that Milord, there is no violation of the provisions of the Act and the appeal are accordingly disposed of.
Yes.
Then, Milord, I need not to refer Milord that page 44 because that was a writ petition which I have annexed. Another writ petition. I need not to refer that writ petition, but the order I want to refer Milord at page 83.
Yes.
Page 83.
Yes.
Because they also appear in that matter. So the only prayer of the petitioner is for a direction on the concerned respondent to consider and dispose of a representation made by the petitioner lawyer on 11 November 2021, which is in the nature of a complaint against the alleged illegal construction raised by the private respondent number 1932. Yes. The petitioner of the respondent are represented, counsel appearing for the state respondent submits as a responsibility, being the assistant engineer, so and so, shall dispose of the representation of the petitioner. So and so is accordingly disposed of with the direction upon the responsible chief to dispose of the representation it is so and so by passing a reading order within a period of 5 weeks from date. The petitioner as well as the other necessary parties shall be heard. So before passing a reading order, the order shall be made available to the petitioner in a week from date on which the said order is passed. Needless to say, the concerned respondent shall take into account the provisions of the West Bengal Act and before passing the reading. Now this is the entire thing has been started from this one. 83, I have told you also the 83. Next, Lord, in terms of this order, Lord, the notice has been issued, Lord, at page 88.
Yes.
Page 88, you Lord, will see that this is the notice issued by the concerned authority. Thereafter, your Lordship kindly come to page 89, wherein Lord, the joint inspection report was held. Joint inspection was held, though no report was given to us, but the inspection was held, and for that a notice was issued. 89. Then, your Lordship kindly have a look of the page 91, that is the 10-1 notice.
Yes.
Assistant engineer, all the blood opposite parties or respondents of the petition of your Lord. Your Lordship will find.
Yes.
Then, your Lordship kindly have a look of the page 90. The order was passed.
Yes.
There are two notices. One is 91 and 92.
Yes.
10-1, 10-2 notice is 92, and thereafter the order was passed at page 93.
Yes.
93, the order was passed. 10-3 authority. 10-3 authority, this order was passed on 6 August 2024.
Yes.
Then, my lord, we filed the writ. Thereafter, my lord, I have shown to your lordship case started there. In this case, my lord, page 86, 87, that two documents, 86, 87, two documents wherein, my lord, it is recorded that the land of 1778 was not acquired by the government. But another land was there that was acquired land. On the basis of that, that land, my lord, the road was there. The highway is there. Thereafter, my lord, your lordship kindly have a look of the 6th August 2024, we filed the writ petition. The first order, your lordship kindly have a look of that, page 94. This is our writ petition. It appears that in the pendency of this writ petition, an order dated so and so was passed by the so and so so and so. A copy of this order has been made over to the court by the learned advocate appearing for the petitioner. It has been submitted with the learned advocate appearing for the petitioner that two petitioners approach the so and so to file an appeal against the order dated said appeal has not been received by the authority which compelled the petitioner to prepare an appeal before the learned district judge so and so. A copy of this said appeal registered as Miss Appeal number so and so has been made over to this court. No doubt a statutory appeal in terms of section 10 post right so and so. Since it has been submitted by the learned advocate application that appeal has not been received by the district magistrate, I am inclined to stay the operation of the order dated so and so. So and so. Thereafter, the first order of stay was passed on 12th September.
Yes.
Then, Lord, the next order that was continued till 30th April 2025 at page 93. Page 96, that was continued till 30th April 2025.
Yes.
Thereafter, Lord, the appeal was referred. Page 97, I need not to travel to a lordship the merits of the appeal. This appeal was referred. After that, my lord, page 93, then my lord, the 97 appeal. Thereafter, the order was communicated 117. There are as many as 5 orders. The last order is at page 170. 22nd April 2025. Report regarding acquisition of RA Taylor plot number 1778 Mouja so-and-so has been received from special LAO by this memo number so-and-so, dated so-and-so. As per the report, RS plot number so-and-so has been acquired for construction of road from Kochubaria to Gangasagar in LA case number so-and-so. The award for 0.33 acres of land in RS plot number so-and-so has been declared in the name of Jyotindra Maiti, Vishwanath Maiti, and has been paid. So out of this, there are a big land on this sub number. Only 0.33. Thus, considering the submissions of the appellant, the opposite party, the report of demarcation conducted on 19th February 2025, though not surpassed, the earlier demarcation report submitted by so-and-so dated 12th March 2024, submitted from the end of the Bilero Sagar and the report of special LAO, it appears that the appellant being so-and-so have structures over PWD land in RS Taylor plot number so-and-so and so-and-so in Mouja so-and-so are thus liable to be removed. Thus, the impugned order dated so-and-so of subdivisional officer is hereby upheld. So, the order under 10.3 is upheld by this order. And below the accordingly remove the enforcement with this the appeal is hereby considered and disposed of. Now this was the disposal on 2nd April 2025 when below the stay order was there passed by the Supreme Court. 30th April up to 30th April.
Yes.
And this order was communicated to us. If your lordship kindly see, this order was communicated to us on 15th July at page 112. Order was passed on 22nd April 2025 and the order was communicated to us on 15th July 2025 at page 112. Thereafter, below, the writ petition where below the injunction was passed, stay was passed. That was taken up for hearing.
Yes.
That was taken up for hearing on 5th May 2025 at page 118. Lord, your Lordship, kindly I will go that. This court has heard the learned advocate for the petitioner, the learned advocate for the respondent state, as well as learned advocate for the private respondent number 12. The subject matter of the instant petition are the notices dated so and so as issued by the response 6 and response 7, respectively. By filing the instant petition, that state for issuance of appropriate heat or heat against the responding authorities, more specifically against the response 6 and 7 for causing the in course of hearing, an advocate for the petitioner at the very outset submit before this court that the after two notices is so and so and so and so cannot be sustained in the eye of law since while issuing the two notices under challenge the issue number 6 and 7 has miserably failed to visualize that plot in postal so and so and so is royalty land and is not a vested land and is not used for the purpose of right. It is submitted that on account of such perversity, appropriate relief will be granted in terms of years of history. In course of the submission, attention of this court is also drawn various orders that passed by the court and benches of this court, whereby and whereunder the state court and benches, according to the prisoners have dismissed the earlier decision that's filed by the family. Per contra, so and so, advocate appearing on behalf of the respondent state and its functionaries at the very outset draws attention of this court to section 10 of the State Act of 64. It is submitted by so and so that in terms of section 10(3) of the State Act of 64, the present petitioners have the alternative remedy and the petitioners have every opportunity to raise their objection in proceeding as indicated under section 10(3) of the State Act of 1964. In the event the petitioners fail to comply with the requisition of the notice under section 10(1) of the State Act of 1964, this further submitted by so and so that even after section 10(4) of the State Act, the petitioners have further remedy for preparing an appeal before the district. It is submitted by Mr. So and so that in view of the ability of the alternative remedy as well as in view of the absence of any perversity in the notices under challenge, the court must be very slow in passing any favorable orders in favor of the petitioner. And the advocate appearing on behalf of the private respondent so and so, because the submission of Mr. Banerjee and the advocate appearing on this court has perused the entire material as placed before this court, including the two notices dated so and so and so as passed by the number 6 and 7 respectively. This court has also given an express consideration over the submission of the advocate for the concerning parties. This court considers that for application of the instant is the provision of section 10, therefore the provisions were reported. Then below paragraph page 122, paragraph 12. On careful perusal, I will also got it. On careful perusal of the aforementioned legislative provision, I look to the factual aspects of this case. It reveals to this court that by issuing a notice, there is notice, there is asking the enforcement in terms of the provisions of section 20. On further perusal of the notice, it means further that there is no 7 has fixed the date of hearing under section 20 of the Act of 20, wherein both the petitioners and private respondents were directed to. In view of such and in absence of any materials to come to a finding that the two notices are either illegal and illogical, and also in view of the fact that the petitioners have generally failed to prove at least by appearance that the aforementioned course of land in the land, this court finds no cogent reason to interfere with the aforementioned petition. In view of such, this court finds no merit in the instant petition according to the instant petition along with the interpretive application being so and so are before parting with this, next paragraph, page before parting with this court directs the present petitioners as well as the private number 10 and 11 and to their authorized secretaries to appear before the 7 authority positively on May 15. But kindly mark me. Positively on May 15, 2025 at 2 p.m. and or also on subsequent dates and time as would be fixed by the 7 for participating in the proceeding under section 10(3) of the State Act of 1964. It is further ordered that in the event the petitioners and the private respondents fail to appear before the 7 authority on the day and hour as fixed by this court and by the respondent number 7, the respondent 7 authority is at liberty to proceed with the proceeding under section 10(3) of the State Act of 1964 in absence of the petitioners and the private respondents and shall come to a logical conclusion on the same positively within 30 days from the date of such appearance as fixed by this court. The time limit as fixed by this court is mandatory and primitive. Liberty is given to the advocate for the private respondent, thereafter liberty was granted to to have a copy of this order. The respondent number 6 and 7 are directed to act on the basis of sample copy. It is made clear that till passing of the final order under section 10 of the State Act of 1964 by the respondent number 7, there shall be an order of status quo upon the aforementioned plot of land and the instant deed petitioner and or private respondent, or the liberty is given to the respondent number 7 to vacate the order of status quo as passed by this court in the event the deed petitioner before this court made any attempt to drag the proceedings under section 10 of the State Act. So in terms of this order, we duly attended the hearing on a particular date and time. Then this matter was disposed of by this order. Thereafter, my lord, I have shown to your lordship that the 10th order has been passed. In the meantime, due to the pendence of the petition, challenging that we prepared the appeal.
No, after this order, when 10th order was passed when?
10th order was passed 6th August.
No,
6th August 2024. 10th order.
here by virtue of this order dated 5th of May 2025,
Right.
10th hearing was directed to be conducted on 15th of May 2025.
Yes.
So it was, you appeared, both of you
Yes.
appeared. What happened after that? Any order under 10th has been passed?
No, not yet.
Whether the earlier order passed under 10th was set aside?
Yes.
Show me by which order?
By 10-4 order.
10th order.
10-3 order. You know.
Please show me by
Yes.
which order 10th order was set aside.
Yes.
Earlier 10th order
Right.
passed on 6th of August 2024. By which order it was set aside? Please show me.
Your lordship kindly have a look of the page 117.
117. Not set aside, it was upheld.
No, no. Here upheld.
I'm asking you initially.
Yes, thereafter
Mr.
challenging.
Raut, please let me clear
It
myself.
requires a lot of understanding. Yes.
6th of August, there was an order passed under 10th.
Right.
That was upheld
By the
by the under 10-4 by an order passed on 22nd of April 2020.
right.
So now there are two orders.
Right.
Now 10-3 order 6th of August 2024
Absolutely.
and 10-4 order on 22/4/2025.
Absolutely.
Now please show me by which order these two orders were set aside.
Well, kindly see the order of this honorable court.
Please show me that 22nd of April 2025 and 6th of August 2025, 4 was set aside. By which order?
At page 127.
127. Yes.
Lecture 316. This is the writ petition challenging the order passed by the 10th-4 of it.
No, Mr. Raut, only one thing. Prior to coming to that order, this order of 15th of May directed a fresh hearing under 10C. But on that date, 10C order was not set aside. If that was not set aside, how could a fresh direction be passed for hearing? Please show me. That is why you have to show by this order, 10C order was set aside.
I am showing you. The page 1.
Otherwise, before setting aside, a fresh hearing under 10C could not have been directed. Because there's already an finding. So unless you show that that order was set aside, no fresh hearing could have been.
On that day, the order was not set aside.
Yes.
That was
So-
there.
Yes. So when this order was set aside,
By
so if that was, it was not set aside, where was the occasion to direct a fresh hearing on 15th of May 2025?
yes.
If the, why a fresh hearing?
No, I am
If the-
not.
Mr. Rao, if the order has not been set aside, that authority, final adjudication up to the appellate stage, whether the subordinate authority can set aside the order passed by the appellate authority,
No,
then
cannot be.
how,
Look,
what, for
I-
what
kindly be
purpose hearing?
Look, I'll be silly. That's why I told, that is my question, Lord. Why this notice was issued to me now?
I'm asking you, why that notice? That is the
Yes,
different
no,
thing.
I'm just,
I'm on a larger
I'm just
issue.
trying to clear.
Nothing, all proceedings remain.
I am just,
Because
Lord, trying
this
to
order
clear
by
your,
15th of May,
I am just, Lord, trying to clear your Lord's mind in this. Lord, here, my lord, when the entry order was there, 6th August, Lord, that was not, my lord, 6th August after that, before that, Lord, 5th May. Can you see that? Lord, just, I have read, my lord, before your lord, the order of this honorable court, which was passed on, my lord, 5th May 2025.
Yes, please show me it was set aside, 6th of August.
No,
So, up to 15th of May
since it
2025.
was not set aside, but, my lord, here, my lord, again, my lord, it was directed to, my lord, appear before the authorities
By the High Court.
by the High Court.
How could that be done? That is my question to you.
Lord, that was done
Unless set aside, unless an order is set aside,
state did not
Mr.
inform
Rao.
anything about the
Mr. Rao, my question to you is, an order passed under 10.3, upheld in 10.4.
10-4 appeal, Lord, your lordship kindly have it, 10-4 appeal on 6th August.
10.3 is 6th
6th
of
August.
August. 10.4 is sometimes in
But-
September.
No, Lord, that was
April.
April 28th,
22nd of April.
22nd April.
So thereafter, the order was passed on 15th of May 2025. So when the order was passed on 15th, all right, 5th of May.
5th of May.
So subsequent to the passing of the order under 10.4,
Yes,
so on that date, 5th of May, 10.4 order was not set aside.
no, because Lord,
come-
we are
Not
dark about
because,
it.
I am coming to that.
Yes,
So 10.4 order was not set aside,
no,
10.3 order was not set aside.
right.
So this order was subsisting between the parties. If that order was subsisting between the parties, how could a fresh hearing be directed by this court?
But because they did not inform the court about the proceeding, Lord, they have taken. They did not inform the court. And we are also on that. We are also on that what proceedings they have taken when the order was passed. I have just shown to your lordship
All right.
that the order was
Yes,
passed
yes,
by
you
the
are trying to
authority.
show page
in the month
127.
Yes,
Yes.
127, this is the order
Yes.
where, this is the writ petition where it will have challenged the 10-4 authorities order. Your lordship can level with that.
Yes.
The affidavit of service is filed on behalf of the writ petitioner is taken on record. The writ petitioner is from state and its instrumentalities and private respondents are represented by their respective counsel. By filing the writ petition, the petitioner has paid for issuance of appropriate decree against the authorities, more specifically against the authority for passing the order dated 22nd April 2025, 10-4 of it, as passed in appeal number so and so, whereby and whereunder in a proceeding under section 10-4 of the Act of 64, the respondent number 2 authority dismissed the appeal as preferred by the petitioner. It is pertinent to mention here that the petitioner preferred their appeal challenging the order dated 6th August. So 6th August and order is passed. 10-4 authority order is passed on 22nd April and 10-3 authority order was passed on 6th August. On careful perusal of the two orders dated 12th September 2024 and 6th March 2025 as passed in WPA number so and so by two separate coordinate benches of this court, it reveals that in the petition as filed by the present petitioner, the subject of challenge was the order dated 6th August 2024 as passed by the respondent of 7 authority, which was stayed till April 30th 2025. It reveals that despite such stay, the respondent number 2 authority disposed of the appeal as preferred by the appellants, who are the petitioners before this court on 22nd April 2025, ignoring the order of stay as passed in connection with WP number so and so, which have been annexed at page number so and so of the petition. At this juncture, Mr. Rao, an advocate appearing on behalf of the petitioner, draws the attention of the court to page number 117 to 123 of the instant petition, being a copy of the order dated 5th May 2025 as passed by this court in so and so, whereby and whereunder this court, while disposing of the petition, directed the present petitioner and the private respondents to participate in the proceeding under section 10(3) of the said act on a particular day. On being asked by this court, so and so submits before this court that on the day of hearing so and so, that is on so and so, the present petitioners were not aware of the order under challenge dated 22nd April 2025. They have also not informed before the court. Since the same was communicated to the petitioner on 15th July 2025 under cover memo, which has been annexed at page number 22. It is thus submitted by so and so that when this court permitted the petitioners and the private respondents to approach the respondent number so and so for adjudication of the proceeding under section 10(3) under the said act, the impugned order under challenge dated so and so as passed by the respondent authority as per the provisions of section 10(4) of the said act cannot be allowed to stand. It is further submitted by Mr. Rao that pursuant to the direction passed by this court on so and so, in so and so, both the petitioners and the private respondents have already appeared before the Court of 7 for participating in the proceedings under section 10(3) of the said act and before the respondent of 7 authority hearing under the provisions of section 10(3) of the said act has already been concluded, but no final order has been passed. So this will clear, I think, the mind of the lordships. Such contention is, however, not opposed by the learned advocate on behalf of the private respondent. On careful consideration of the entire materials as placed before this court and after hearing the learned advocate for the contending parties and also considering the chronology of events as discussed in the foregoing paragraph, this court considers that the instant dismissal deserves to be allowed for the following two reasons. The order dated so and so was passed by the respondent to authority in an appeal under section 10(4) of the said act when the operation of the impugned order before him was stayed by this High Court in connection with so and so. This court, while disposing of the so and so, permitted the present petitioners and the private respondents herein to participate in the proceeding under section 10(3) of the said act before the respondent of 7 authority herein on a specified date, that is on so and so. Accordingly, the instant petition being number so and so is thereby allowed. Consequently, the order under challenge dated so and so as passed by the respondent number 2 authority in appeal number so and so is hereby set aside. Since the appeal has been set aside, by which below the order of 10(3) authority was upheld.
That is also set aside. That's the interpretation of law. Please show me an authority.
Lord,
Suggesting, Mr. Rao,
Lord, your Lordship can come.
if an order of the subordinate authority is upheld by the appellate authority, by setting aside the appellate authority's order, the original authority's order will also go. You're suggesting.
Lord,
What are you suggesting?
Lord, I have, Lord, judgment on this point.
You show me the judgment.
That Lord, because Lord, I have seen one judgment on this point.
Please show me the judgment.
Lord,
Unless
Lord,
that is set aside, cannot be done. Because in remand, Mr. Rao, the trial court, while remanding, that judgment is also set aside. Otherwise, they cannot go. It's only the appellate authority's order which is set aside. Trial court's authority order remains. Suggesting.
Lord, I have to.
But here also,
I have to.
we could have.
I will try my level best not to. On this point, I will try my level best.
So so according to you, by virtue of this, the 10(3) order was also set aside, and
Not by virtue of that. Since Lord, the order of the appellate authority has been set aside, by which the order under 10(3) was upheld.
yes,
So if the order, Lord, order cannot go one. If order goes, everything goes. Everything goes according to Lord my interpretation. So Lord, my responsible submission before your Lordship that the order under 10(3) and order under 10(4) both are good. Both are gone.
when it was set aside.
Lord, this was set aside on
If I
28th
accept
August,
your submission that 10(3) also goes, when? On which?
28th August 2025.
28th of August 2025. So on that date, 10(3) and 10(4) order has been set aside.
Yes.
Now after that, any hearing?
The further hearing does not arise because the hearing which was earlier taken, at that hearing we attended the hearing.
Mr. Rao, it was set aside only in August. So do you mean to say till August it remained? So further hearing, that is why I asked you. 5th of May 2025, 10(3) order was not set aside.
No.
If that was not set aside, there was no occasion for a further hearing because as on that date, 10(3) as well as the appellate order 10(4) was in force.
Up to
So, Mr. Rao, I can explain you,
yes.
giving another example.
Yes, yes.
So let us for a moment assume an SLP is pending against a decision.
Right.
Now, a direction is passed. Yes, trial court, please hear the suit again. And the SLP, on a subsequent date, all the decisions are set aside. Will you mean to say trial court hearing on that date that will suffice? Suggesting. That is why I asked you, if you take instructions, you will not participate, I will record that. I will give them liberty to participate. That is suggesting that was on a date prior to setting aside, even if I accept your submission, that was on the date 10th order was set aside.
Yes.
So after that, hearing has to be given. Other than you will say, yes, it was set aside on this date. Yes. If you choose, you say, I do not have anything to submit, I will record that. I will give them opportunity to appear and I will direct them to conduct a
But
hearing.
in the instant, it becomes
It's
not,
your choice, I will record that you do not wish to appear again.
not only to appear, but
Mr.
also.
Rao, what is the
I-
difficulty if you appear? Only the notice has been given. You appear, you raise all points because the order under 10(3), even if I accept your submission, it was set aside on 28th of August 2025. It's only after the order has been set aside and authority effective hearing can be given. Otherwise, the decision on 10(3), 10(4), both are binding upon that authority. That authority cannot pass a decision overriding those.
Not the, if your lordship accept my submission.
Even if I accept your
Yes, sir,
submission,
I'm just trying to assist you. If your lordship accept my contention that the order under 10(3) and 10(4) have gone
on 28th of August
on
2025.
28th of August 2025,
Yes. So what is the effect of any hearing prior to that date?
not prior to that date.
When it was heard? When the hearing was taken place? Please show me after 28th of August you are heard 2025.
The questions of issuing this notice by the 10th already does not arise. That is my question thereafter.
Mr. Rao, I'm asking
If they want to
show me
proceed
when you
outside,
show me when you participated in a proceeding under 10(3) after 28th of August 2025.
I have not participated.
So
There is
Mr.
no
Rao, Mr. Rao, I think you are not understanding the query of the court. Something is in your mind, you are not successful in getting those from those ideas. 28th of August 2025, according to you, the order under 10(3) and 10(4) was set aside.
Right.
So after setting aside, a hearing is given when an order is set aside. We are doing in almost all cases, in all proceedings. After setting aside, a fresh hearing is to be given.
No, that was not the direction of this honorable court. According to me,
It's
not
very
even-
difficult.
not only
You
one.
are at that stage arguing this. It's difficult for me to digest.
not only
28th of after setting aside, what is the principle of remand? The hearing prior to that is from a trial court judgment and appeal is preferred. Appeal
Right.
court set aside that order and remands to the trial court.
But here there was no remand.
All right, please make your submission.
Well, there only one.
Yes,
Here,
Mr.
here,
Yes, please. Yes, yes.
yes, here there is no
So
remand.
according to you,
According
so
to me,
since there was a hearing fixed, there was no necessity to fix the further hearing.
since the hearing was concluded on the earlier occasion, no further is requirement. And
Anything
even
more,
if
Mr. Rao?
even if fresh proceedings under the 10 of the Act of 1964 is taken, then it has to be taken from 10(1).
So follow. Yes. Anything more, Mr. Rao?
No. Then last 132 page,
Yes.
that is the impugned. Look, kindly just for a moment, kindly see the impugned notice.
Yes.
A letter received under section 10(2). Again, 10(2) account. Your lordship is saying the 10(3) hearing.
Yes.
Kindly see the 17th November 2025. Again, Lord, after received under section 10(2) of the West Bengal Highways Act from the assistant engineer so-and-so, by this memo dated 12th November 2025, in connection with so-and-so, a hearing under section 10(3), statute 10(3) of the so-and-so will be conducted at the office chamber of the undersigned on 16th December 2025.
So according to you, this could not have been done since hearing was conducted prior to that.
But to that, we are in terms of the order of the
Yes,
honorable court.
followed. Yes, yes, what is the submission? You are for the private respondent. Yes.
Further order, this is on page 130. But consequently, the order under challenge dated 22/4/2025 as passed by the respondent number 2 in appeal number so and so is hereby set aside. My lord, if the order under by this appellate authority has been set aside, it does not imply that under section 10(3) it has been set. My lord, that is my only submission.
Yes, Mr. Smith.
My lord, my learned friend, my lord, show that portion. That portion, my lord, the commanding portion of the journey.
Yes.
What order was set aside? It is further order that all consequent actions taken by the respondent authorities, including the respondent number 6. Respondent number 6, my lord, has to pursuant to the aforesaid order, dated Apo are also set.
Pursuant to the state order.
Yes,
Pursuant to the state order is after that.
yes, my lord, after that.
So after that, all actions
Taken by the.
from 22nd of April 2025 and subsequent
Right,
to preserving the previous.
Yes, ma'am. Let us say. So, my lord, we are bound to, as per order of this. That portion is, my lord, guided portion. That is, you must go to start from that. That is the direction. Before parting with, it is however made clear that the disposal of the writ petition in favor of the writ petitioner shall not have any effect in the proceeding. Before the respondent number 7 authority under section 10(3) of the said act, hearing of which has been claimed to have been concluded.
When 10(3) hearing was concluded,
That is the before that, my lord, before first concluded, that is the 10(3) hearing was concluded, where he, my lord, they challenge that authority hearing specified date পুনরুপায় 5th May. কত গো? 5th May? না, 5th May না। 93, page 93, my lord.
Yes.
15th May 2025. 15th May.
15th of May
15th
2025.
of May 2025, and within 30 days from the date. Last date was 15th May, and the last date was within 30 days from the date of birth.
Mr. Rao, page 117. You are the appellant in saying 4.
Yes.
So,
You
yes, 117.
Yes.
So you participated in the hearing on 22nd of April 2024.
Right.
You are aware of the interim order passed by the court.
Yes.
Did you communicate this interim order to the district magistrate when the order under
Yes,
on,
yes, yes, yes. Yes, you have communicated.
where is that?
No, that communication.
No, on that day, did you say no, this hearing cannot be conducted
We have
because
communicated.
Mr. Rao, please let
Yes.
me make my question. On the ground that there is an interim order, first.
Yes.
Second, Mr. Rao, what is the effect of an order of stay of an order? What's the difference between an order staying the operation of an order and an order setting aside or quashing the same? What's the distinction
No,
between that?
stay of the order means.
What is the effect of the stay order? So appeal cannot be heard.
Appeal can be heard. Appeal can be heard.
Appeal can be heard,
Yes.
even in spite of the stay order. But
Yes.
that's the only ground on which the coordinate bench has set aside the order under 10(4). How could that be done?
That I can't give.
Yes.
That I can't give any answer.
If you want me to reopen, everything will be reopened.
That means.
Yes, that
how
was the
can-
only
how
ground,
can-
that was the only ground
can
on
only-
which could not have been set aside.
I can.
Could not have been set aside.
I have just come. But first, I am answering your lordship first query. Your lordship's first query is that whether we have communicated the order or not. We have communicated the order
But
twice.
he participated in the hearing.
Yes,
Because Mr. Rao, you also know the position of law that stay of operation of that order does not prevent the appellate authority from conducting the hearing. That is why you participated.
yes.
That is why you participated. And before the writ court, you have said, yes, there is an interim order, please set aside. And it was set aside only on that ground. That cannot be a ground for
There are
setting
two
aside the
grounds.
order. Because stay of order is,
No, there are
and
two-
setting aside,
Lord-
when the order is in subsistence, appellate court
Lord,
can
the
hear.
order of 10-4 authority was settled on two grounds.
So that's the well set.
Two grounds. In
Yes,
two grounds.
one of the ground is,
Lord, one of the at page no, your kindly.
yes. One of the
One
ground
of
is,
the grounds is at page 130.
yes,
One of the grounds is that 10-4 authority has passed the order when the order dated 22nd April 2025 was my lord in operation. The order dated 22nd April 2025 was passed
when
by
the operation of the impugned order before him
Yes.
came was stayed, that could
Yes.
not have been a ground for setting aside. Because you have just now said, yes, appeal could be heard. And that's the correct proposition of law. That is why I asked you the distinction between.
Nobody has prepared an appeal against this order.
Maybe Mr. Rao's error apparent can be also gone into.
That is up to your lordship's prerogative. For that note, I can't say anything.
Yes, could not have been a
But the
ground
record,
for setting
record-
aside. Because
and the second,
two,
the
three
second
things.
is there.
When 10-3 and 10-4 order was subsisting, no direction for hearing before the 10-3 could have been granted. Mere order staying the operation does not prevent the appellate forum from conducting.
No,
These are the two grounds on which it was set aside.
I am not.
So that will be revived. 10-4 order will be revived.
But I am not saying that this appeal court, my lord,
That is why I am
cannot
inviting
proceed
you.
with the matter.
That is why I am inviting
But
you.
cannot,
10-4.
appeal court, appeal authority cannot not pass the order unless the stay is vacated by the High Court or unless a specific, my lord, direction is given from this honorable court.
Mr. Rao, there was no stay of all further proceedings. before the
Yes,
appellate.
My
No
lord, the
stay of operation of the order.
order, stay of the operation of the order.
Stay of the operation of the order and stay of all further proceedings are two different concepts. Also.
Yes, yes,
Then,
absolutely. Absolutely.
then there was no stay of the on the appellate authority. What are you suggesting?
No, I am not saying that.
So
proceeding
could have
was
been
stayed.
done, and
I am
this is
not-
the ground
I
on
am
which
not
it was set aside.
No, I am not saying that stay of operation of the order does not mean that appeal authority will not
But
proceed.
this was the
They
ground
will
on which
proceed.
it was set aside.
And the next ground is also there.
Yes, yes, yes.
This court, while disposing of the so and so, permitted the present petitioner.
Could not have been also done when 10-3 and 10-4 order was enforced. Two grounds cannot be sustained. That also could not have been done when 10-3 and 10-4 was enforced. Before this date, it was not set aside. So when the order of the appellate authority was enforced, the subordinate authority could not have been directed to conduct the hearing.
If your
These
lordship,
two grounds, none of the grounds can be sustained.
if your lordship will permit me to say one thing, this order was passed on the basis of the submissions made by the state that this, and as well as they did not enlighten this honorable court about the actual facts of the matter.
Facts
Because
are
of that
there.
reason, this order.
Facts are there. Everybody is there.
No,
Facts were there.
Facts from the
I am only asking you what is the effect.
Facts from the petitioners are there, but what has actually done by the authorities that was they were not yet enlightened to this court. Because of that reason, this type of order was passed.
These are the facts. It was taken note of. All these facts
That
are
is the
jotted
facts
down,
of the petitioner.
and it
What
was
the petitioner-
interpreted in one way on the basis of your submission that it could not have been done. On that ground itself, it was set aside. None of the grounds on which it was set aside can be sustained.
Only one submission I can, my lord, against this order, nobody has prepared the appeal, so let me attend the final. That is the final.
An error is apparent on the face of the record, Mr.
Your lordship can exercise your lordship necessary power and
226.
pass the necessary order.
226 it can be done.
Your lordship will exercise your discretionary power and pass the necessary order flow. I don't want to object anything, my lord, for that.
I was keeping quiet, I was not going into that extent. You are making these submissions, that is why I kept quiet. Because I was not on the very first day.
Frankly, I'm submitting to your lordship that, my lord, these types of order was passed by the Honorable Court simply on the basis of the submissions of the learned advocates appearing for the state by
That is
not
why Mr. Rao,
properly giving the.
Mr. Rao, I asked you to prepare an instruction.
So that I can also. I can also.
Now it is not required. That is why I asked you to prepare an instruction. Everything would be clear.
Yes, Lord,
So many writ petitions, so many orders, we effect.
Your lordship has rightly asked me, my lord, to prepare the list of dates and to submit before lordship. That's why, my lord, yesterday, my lord, I have submitted to the entire, my lord, the brief list of dates, and lord, today, my lord, I have submitted, my lord, the document, my lord, which I have annexed with the writ petition by showing the actual, my lord, what has happened in this case. Apart from the merits of the case. Apart from the merits of the case.
You have not argued what is the effect of a stay of operation, stay of all further proceedings, setting aside. These are the distinctions which could have.
I am saying before your lordship.
Hard.
Oh, my lord, what? That's why, my lord, I have submitted that 10-4 authority passed the order on 22nd April.
Yes, I will
And
consider
lord,
everything.
and
Yes, call the
lord, the
next
order
matter.
was committed to ask my lord on 15th July.
Matter.
Item number 21, my lunch. The respondent has been called for to submit a application. Report was called for this to while a report would have found the evidence. Also, the joint investigation was done, and also the report, the report. Now, while dealing with
You have filed a report.
no, not filed. Dealing with the report, because some more documents are required to be added. Now we have prepared able to prepare a comprehensive report. This will be upon tomorrow. So, and it's a matter the next week anything.
The learned advocate appearing for the yes, been 2 years. Yes.
This is the petition primarily free for a direction on the respondent number 2, so that the case which was registered back in the year 2022.
What is your prayer? Recording of your name in the record of right.
Apart from that, prayer B and prayer E.
Prayer B. What is prayer B? What is the mistake for?
What has happened is the grandmother or the father of the petitioner had donated.
What is the mistake for? Recording of your name in the record of right.
Yes, my father's name was.
Please approach the tribunal for that.
The prayer just all that I'm praying for is a direction that the.
Innocuous prayer that also cannot be granted. Today in the morning I was handed up वही मैटर तक होता है
that are given are 1 year apart. As it is, 4 years have passed. Petitioner is suffering.
That cannot be a ground. The petitioner has approached this court. One minute. Yes.
In
You
this
are for the
Milord, again and Milord, I assume Milord that I am Milord responded on the 7th. Milord, I assume Milord I am Milord
Yeah, you.
because Milord no amended writ petition has been served upon me, Milord, so I have to assume.
Who amended?
Perhaps Milord, the fourth petition, Milord, not the amended petition.
No. I've served.
Yes, Mr. Raut. Have you
No,
not
I've
served? Started to be served. Out if it is not served, please give me.
Yes, it was.
Take it only not today.
Lordship, you can take it up, Lordship. I have, since I have appeared, Lordship can take it up, Milord.
All right, give him a copy, not today. Yes, call the fifth matter.
Item number 161.
Milord, I appear for the petition.
Yes.
Mr. Mitro, my lord, had almost concluded. Just a quick recap because there has been, my lord, some time, my lord, gap. My lord, the challenge in the, my lord, revisional application is, my lord, the order passed under order 13A of the, my lord, Code of Civil Procedure. This property, my lord, this is, my lord, in respect of an eviction suit filed in the, my lord, commercial court at Rajasthan.
What is the stage at which this application was filed?
My lord,
What was the stage of the scheme?
my lord, before they had filed, my lord, the written statement. At that stage. Now, my lord, my suit, my claim proceeds on the basis of a termination.
Just a small correction. It was not filed before the written statement was filed. It was filed before the issues were filed. Issues are not filed.
There was an application for
It
acceptance
has
of
not been framed, but have you filed the written statement?
Statement has been filed, it has not been accepted. It is pending for acceptance.
So unless it is accepted, it's
in commercial, my lord, dispute unless there is an application within, my lord, the outer limit of 120 days, giving an explanation, my lord, there is no written statement. That's the, my lord, law as it now stands. Now, my lord, so far as my suit is concerned, this is in connection with an immovable property on VIP road. My lord, the property measures approximately 43,000 square feet, and my lord, there is another, my lord, area for car parking, my lord, that is another 5,500 square feet and all, 48,640 square feet. Now, this property was, my lord, given on, my lord, lease, this, my lord, defending. My lord, there was, my lord, the terms included, my lord, what would be the terms of payment, 3 years interval, what would be the, my lord, increase in the, my lord, rental. Now, after, my lord, or during, my lord, COVID, what they do is, my lord, unilaterally, they propose alteration of the, my lord, fundamental term of the agreement. On one hand, they say, I am going to continue in possession, but they would say that whatever revenue is being generated from the property, I would give you 2% of the, my lord, net revenue generated out of the property. And this is really, my lord, the stage from which, my lord, the disputes emanated between the parties. My lord, we write to them. In response, they write to us, taking this stand, and they saying that we are going to offer you this, and they continue doing that.
Ultimately, my lord, the agreement contemplates that I have to give him notice if there is a material breach, and I have to give him notice of 30 days for him to cure. If not, another 30 days, my lord, and then my lord, I can take steps, my lord, to prosecute, to my lord, institute an action. We, my lord, give him a notice, and there is no dispute that this termination notice has been received by them, because they have replied to that notice. In the reply, their stand has been consistent that because of the force majeure clause in the contract, I was not obligated to pay you whatever was agreed in the agreement. Now, the, my lord, force majeure clause, which is there in the agreement, it is very, my lord, specific. If there is, my lord, a destruction or damage in the property caused by the my lord, force majeure event, then, my lord, that clause kicks in. That's the, my lord, language of the clause. And there are, my lord, now, my lord, force majeure clauses after COVID, they have, my lord, received interpretations. It's very strict interpretation. And in, my lord, one of the cases, it has also been held that a lessee cannot be allowed to rely on a force majeure clause and alter the terms of the agreement, yet continue in possession. Unilateral alteration would not be permitted. So, my lord, we filed the suit, and in aid of the suit, we filed this application. I mean, in order 13A application, it is, my lord, slightly, my lord, the degree of, my lord, so far as, my lord, my entitlement of a decree to a decree under, my lord, order 13A, my lord, is far more, my lord, easier than, my lord, in a, my lord, judgment upon admission application. Because in a judgment upon admission application, I have to show some written admission on his part to be
What are
entitled
the
to a
two
decree.
tests under order 13 capital A?
My
Two
lord,
tests
there
for
is-
you to get a decree.
My lord, there is no plausible defense of, my lord, at the language from the statute itself, my lord.
Yes, yes, from the statute.
From the
So
statute.
there is
My
no
lord,
plausible, there is no plausible defense.
Yes.
So unless the defense comes, Mr. Dotto, it's not accepted. Can this be hailed that they do not have any
My lord, this would,
plausible
my lord,
defense?
yes, my lord, in my respectful submission, yes, because, and that is not on the ground on which the learned judge rejects. The learned judge has rejected.
Maybe a different
will-
ground,
I
but
will-
I can supply the reasons.
Of course, and I have to satisfy your lordship that this, my lord, lordship should not hold this, my lord, in this case. I'll try and, my lord, persuade your lordship on that. But before that, may I take your lordship through order 13A, and then I'll come to the documents in the, my lord, petition.
Order 13A application or the
No,
provision?
the provision, my lord. Because I want to show, my lord, the provision, and then, my lord, the documents to justify how I fit into this provision.
Yes.
My lord, under the, my lord, CPC, my lord, as amended by the Commercial Codes Act. My lord has.
এটাতে অ্যামেন্ডমেন্টটা নেই দেখি you have a copy of Commercial Codes Act amendment? That amendment here it has not been incorporated.
My lord takes my book. I will, my lord, take it from my
Let
lord.
me check up from this.
No. My lord kindly takes this book. I have another, my lord. I have.
Here it is. Yes, I've got. Yes.
Thank you. Order
Yes.
13A, my lord, rule 1. Sub-rule 1. This order sets out the procedure by which courts may decide a claim pertaining to any commercial dispute without recording oral evidence.
You can skip 1 and 2. You can start with 2.
Stage
Because
for
two-
application. Stage for
application. Yes.
An applicant may apply for summary judgment at any time after summons has been served on the defendant. So, my lord, from the language itself, it is clear. Provided that no application for summary judgment may be made by such applicant after the court has framed the issues in respect of the suit. I have not crossed that stage. Grounds for summary judgment. The court may give a summary judgment against a plaintiff or defendant on a claim if it considers that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim. I fit in the, my lord, second limb here, because defendant has no real prospect
Yes.
of successfully
So,
defending the claim
yes. My question, Mr. Datta, to you is
without a written statement.
if you want to come to the second limb, because you will not be on the first limb because that's
Yes.
against you and they have not come
No,
up.
they have not come up. Yes,
Yes.
they have not come.
So you are on the second limb. So second limb is real prospect of successfully defending unless their stand in the written statement comes, can this be decided whether they have any real prospect of defending on?
My lord, in my respectful submission, subject to my lord's kind consideration, Order 13A Rule 2 answers this,
No, Mr. Dattu, yes.
that I can, if I can
Because-
apply, I
because-
can invite the court to adjudicate.
Because these provisions are to be read as a whole. Let us take a case where the defendant comes up and says this is to be dismissed. It will come under the first limb, then he is not required to file a written statement. But when
The
the
defendant
plaintiff,
has said that. Defendant has said that by filing the written objection, that please don't pass a decree.
no, that is a different thing. If the defendant comes up and says, please dismiss the suit, he does not have anything. That also summary judgment the defendant can get. So that, for that, the written statement may not be filed. The tests under Order 7, Rule 11 would suffice. He can come and say, yes, look from the plain, he cannot succeed. Straight away, there is no requirement to file a written statement. Tests as in Order 7, Rule
And
11.
this, my lord, stand
But
can be.
if you plaintiff wants to have a judgment on the second limb, so unless their defense comes, can the court render a finding saying, no, the defendant do not have any case?
My lord,
Because they have to make out a case
no,
first.
the case has been made out in the written objection. It's not that I am moving an application ex
Objection,
parte.
written
My lord, his
objection,
case in the written
defending
statement.
the claim is a different thing. Defending the claim has to be by
My
way of a
lord, then
written
in that
statement.
event, the statute would have been very conscious, the legislature would have been very conscious
Legislature is
in,
very conscious because
my lord is reading into the, my lord, provision, something which the
Sir,
legislature has not incorporated.
Mr. Doctor, there are two outer limits. One is after service of summons, prior to framing of the issues. This is the window.
Yes.
Now, there are two options. One, the defendant can pray for a summary judgment.
Of
Plaintiff-
dismissal.
Summary judgment. Defendant has to be by way of a dismissal. Plaintiff can also apply for summary judgment by way of decreeing their claim either in whole or in part. So when it comes to the plaintiff, so it will be the second limb.
Yes.
That
May
the
I read
defendant-
may I read 3 once again?
Yes.
Give a summary judgment. It says against a plaintiff or a defendant.
Yes,
So it
so
is
both.
against a defendant here.
It's
It is
against the
both. Yes,
defendant.
it is both. I
Yes.
am proceeding against a defendant.
Yes.
Against a defendant on a claim if it considers, because I am proceeding against a defendant, I am relying on the second limb of 3A.
Yes.
The defendant has no real prospect of successfully defending the claim as the case may be.
As the case may be, is plaintiff or the defendant.
I pause here for a moment. In our original side, we have a provision of chapter 13, Lordship is aware, where my lord, a similar my lord language is used that there is no real prospect of defending the claim. And my lord, even before a written statement is, though the expression used is claim, my lord, without a written statement being filed, my lord, decrees of eviction upheld up to the Supreme Court, my lord, already done. In my lord, our original side commercial division, my lord, Order 13A, my lord, in a eviction suit or in my lord money suit, my lord, applications filed, my lord, every day we are doing it. Applications we are filing under Order
This issue
13A.
has been decided anywhere. Whether this issue of real
Written statement is necessary
yes,
or not.
before, yes.
I'll to answer
Because
your
this
lordship's,
is
to answer
really
your lordship's query,
maybe
but I will
Mr.
definitely.
Doctor, I'm not disputing that the decrees have been passed. But the question is whether this provision has been taken into consideration and interpreted.
I will definitely, my lord, look into it from this angle once again, my lord. But I will, my lord, even otherwise, my lord, try to, my lord, persuade your lordship to hold in my favor by relying on the other provisions of
Yes,
this.
other provisions you can
3A
place.
is what I am relying, and then kindly comes to 3B.
Yes.
There is no other compelling reason why the claim should not be disposed of before recording of oral evidence. So in a suit for eviction based on a notice under, my lord, the 106 Act, my lord, what I am required to, my lord, prove is, my lord, the existence of jural relationship of landlord and tenant, and that I have, my lord, served the notice of termination and he has received it. My lord, when I take your lordship to the impugned order, lordship will find that to dismiss this application, the learned judge has come to a finding, which is, my lord, according to me, my lord, in my submission perverse, that evidence is required. Now, when I show your lordship the, my lord, notice of termination, the clause in the contract and his reply, Lordship would see, my lord, if Lordship had been, my lord, the first court, whether Lordship would have still felt that evidence is necessary or not. If I cross this hurdle, my lord, I get, my lord, an order as I am praying here. Now, my lord, kindly comes to 4. An application for summary judgment to a court shall, in addition to any other matters the applicant may deem relevant, include the matters set forth in subclauses A to F mentioned hereunder. What are those, my lord? The application must contain a statement that it is an application.
So according to you, you satisfy this
Satisfied,
procedure,
yes,
and there is no observation of the trial court that for this it was.
Yes.
So let us not go into that, which is
Very well.
any other
Now, my
relevant
lord, kindly
provision.
comes to 3, my lord, in that case 4.3.
4
My lord,
subsection 3.
Yes, order 13A, rule 4, sub-rule 3. The
Order
respondent,
order 13A, rule 4, sub rule 3. Yes.
because this also, my lord, gives,
May within 30 days.
yes, of the receipt of notice of application of summary judgment or notice of hearing, whichever is earlier, file a reply addressing the matters set forth in sub-rules A to F mentioned hereunder, in addition to any other matter that the respondent may deem relevant.
Yes.
And my lord, kindly takes one, my lord, provision which is according to be relevant, 4.1D, because in my application I have to avert this. The application must state the reason why there are no real prospect of succeeding on the claim, though there is no written statement, but this averment is there on the claim or defending the claim as the case may be. So when he is replying, he is expected to reply, the defendant is expected to reply on this. 3A says the reply must precisely disclose all material facts, identify the point of law, and state the reasons why the relief sought by the applicant should not be granted. In the event respondent seeks to rely upon documentary evidence in its reply, respondent must do so. Provision is there. Then the reply must state the reason why there are real prospects of succeeding. It is not succeeding, it would be defending the claim as the case may be.
Yes.
The reply must concisely state the issues that should be framed for trial. The reply must identify what further evidence will be brought on record at trial that could not be brought on record at the stage of summary judgment. This is very important. His objection must indicate this. The reply must state why, in light of the evidence or material on record, if any, the court should not proceed to summary judgment. Then, my lord, 5. Evidence for hearing of summary judgment. Notwithstanding anything in this order, if the respondent in an application for summary judgment wishes to rely on additional documentary evidence during the hearing, the respondent must file such documentary evidence, serve copies, so and so. Notwithstanding anything in this order, if the applicant for summary judgment wishes to rely on documentary evidence in reply to the defendant's documentary evidence, applicant is also given an opportunity. Then, my lord, 6 is the orders what can be passed. On an application made under this order, the court may make such orders that it may deem fit in its discretion, including the following: judgment on the claim, this is the highest that I can get. Conditional order in accordance.
You'll be more on B. You'll be more on B.
I would, my lord, at least so far as my claim for eviction is concerned and my claim for admitted areas is concerned,
That is B.
That is A. That is
No,
not
A is
conditional. Yes, B is, my lord, relying upon 7, which is conditional order.
Yes.
I am, my lord, asking for a decree, summary
Yes.
decree.
Yes.
So I rely on A, judgment on the claim.
Yes.
B is, if court feels that no judgment cannot be passed, the next option is, available option to the court is conditional order in accordance with rule 7. I'll come to rule 7.
Yes.
Then C is dismissing the application, which has been done in this case. D is dismissing part of the claim and a judgment on part of the claim that is not dismissed. So this also could have been exercised. E, striking out pleading, and further directions I am not bothering your lordship with E and F. Where the court, 2, my lord, 6.2, where the court makes any of the orders set forth in sub-rule 1A to F, the court shall record its reasons for making such order. Now, my lord, I come to 7. My case is that I am entitled to 6A, a judgment on the claim, at least to the extent of my claim for eviction and also my claim for admitted arrears under the agreement. From this document itself, I'll show that if lordship would have been there, after comparing the documents which were there on record, whether any further evidence was at all necessary or not. Because here we are on affidavit evidence. It is not that, my lord, oral evidence has to come. Now, my lord, kindly comes to 7, my lord. Conditional order. Where it appears to the court that it is possible that a claim or defense may succeed, but it is improbable that it will do so, the court may make a conditional order as set forth in Rule 6(1)(b). This is also in favor of the plaintiff, my lord.
Yes.
Then, my lord, 2, where the court makes a conditional order, it may make it subject to all or any of the following conditions: require a party to deposit a sum of money in the court, require a party to take a specified step in relation to the claim or defense as the case may be, require a party as the case may be to give such security or provide such surety for restitution of cost as the court deems fit and proper, impose such other condition including providing security for restitution of loss that any party is likely to suffer during the pendency of the suit as the court may deem fit in its discretion. And B, specify the consequences of the failure to comply with the conditional order, including passing. So these are, my lord, the provisions of the Commercial Courts Act,
Yes.
of the Civil Procedure Code, my lord, Order 13. Now, my lord, may I quickly take your lordship through few of the documents which are necessary only to come to the conclusion that
First, take me to the plaint once.
plaintiff, yes. My lord, kindly comes to page 35. Lord, 35 it starts, my lord, kindly comes to 37. By a register, may I place it, my lord?
Yes.
My lord, first paragraph is, my lord, by a registered deed of lease
You
dated.
need not place the entirety, the relevant portions which you want.
My lord, kindly comes to first paragraph, which is, my lord, I am referring to the registered deed of lease under which, my lord, the defendant was inducted. The area is mentioned 43,123 square feet and 40 numbers of car parking spaces in an area of 5,517 square feet.
Yes.
My lord, the term is also mentioned in para 1, 9 years commencing from 1st July 2009. It should be 2019. And that's a typographical error because the lease is of 29. Then, my lord, kindly comes to paragraph 4.
Yes.
Defendant paid the lease rent as payable by it in respect of the demise premises under the deed of lease up to March 2020. Yet from April 2020, defendant has wrongfully, illegally failed and neglected to pay such lease rent. In furtherance of its wrongful and illegal activity as aforesaid.
So March 2020 they have paid.
Up to March 2020 they have.
From April they are
From April
defaulters.
they have not. They have not. So, my lord, there is a letter referred to in paragraph 5. By this letter, defendant wrongfully and illegally sought to allege that it shall pay to the plaintiff rent equivalent to 2%.
Add to this 7th of April, you wrote any letter? No.
No, because up to March, my lord, I have
Yes.
received all the payments in terms of the deed.
So they only volunteered in April that they will be paying at such and such rate.
Such and such. It shall pay to the plaintiff rent equivalent to 2% of its actual revenue from 22nd March 2020 till further notice, citing global pandemic
All right.
as an act
Yes,
of.
this is the pandemic they
Yes.
have taken. Yes.
So, we replied to this letter in paragraph 6. The averment is there, 9th of April 2020, wherein plaintiff
You
denied
said that you have to pay as per the terms.
as per the terms. And this, my lord, stand of the defendant has been, my lord, repeated, and we have replied to this stand. Now, my lord, after that, those letters and correspondence, lordship will find reference to in paragraph 7 and 8. Now, my lord, so far as the default is concerned, kindly comes to paragraph 10. In view of the aforesaid, and as the defendant since April 2020 defaulted in paying lease rent in terms of the deed of lease dated 31st July 2019, thereby committing material breach of the terms, conditions, covenants, and obligations under the said deed of lease, the plaintiff became entitled to terminate the lease by giving the defendant notice in terms of the deed of lease. Under the circumstances, plaintiff by a letter of 16 September 2020, caused to be written by its advocate, gave the defendant notice of such material breach of the terms, conditions, covenants, and obligations under the deed of lease, by the defendant as aforesaid, and the defaults committed by the defendant in payment of the lease rent, and called upon the defendant to resolve, rectify such default within 1 month from the date of receipt of the said notice. This is a covenant. There is a covenant in the lease deed which required me to give this notice. By the said letter, plaintiff also informed the defendant that in case the defendant failed to resolve, rectify such default by the date stipulated as above, the lease granted by the deed of lease shall stand terminated on expiry of 2 months thereafter, and the plaintiff shall sue the defendant to recover possession of the leased property being the said demise premises, and also for recovery of the outstanding rent, mean profit and damages at the risk and cost of the defendant. The said letter was received by the defendant on 9th September 2020. Then para 12. In spite of due receipt of the letter dated 16 September 2020, defendant failed, neglected to resolve or rectify the defaults committed by it by the date stipulated as above. On the contrary, defendant by its letter dated 29 September 2020 repeated and reiterated its wrongful and illegal contention as aforesaid. In view of the aforesaid, lease granted by the plaintiff stood terminated on 19 December 2020. Plaintiff became an entitled to recover possession of the demise premises from the defendant by evicting the defendant therefrom. Then my claim on account of arrears of rent is at para 14, my lord, calculated from April 2020 till 18 December 2020 with applicable GST. Particulars mentioned. This, of course, the quantum has now increased. Paragraph 15 is, my lord, about mean profit. Para 16 is, my lord, interest. My lord, in view of, my lord, an urgent interim application, we sought for dispensation.
What was the interim relief you prayed for?
Injunction, my lord, so that they cannot, my lord, transfer income. But
Under what provision this suit was filed of the Transfer of Property Act?
Well, it's a registered lease, and my lord, I had terminated, my lord, the lease in terms of, my lord, the provision in the lease deed itself.
Is it forfeiture under
Well,
111? Which of the clauses under 111 you are trying to invoke in this suit?
Forfeiture is, of course, there because there is non-payment. Material breach is, my lord, non-payment.
Yes. Is it only forfeiture or 111H? Because there is a violation of the terms and conditions.
Possibly Lordship had this in mind when Mr. Mitra was arguing, my lord, this matter. Lordship gave them that opportunity for future to, my lord, come and, my lord, pay this or deposit this. Kindly comes to, my lord, 111, determination of lease. Lease of immovable property determines. Kindly comes to, my lord, G. By forfeiture, that is to say, in case the lessee breaks an express condition which provides that on breach thereof, the lessor may re-enter. 2, in case the lessee renounces his character. I am on 1. Because the other limbs of G is not attracted here. And
it's
then
an express
H,
condition.
there is.
Because they were obliged to pay rent at
Yes.
such and such
And
date.
the moment you breach, in terms of the, my lord, express condition in the lease, I am required to notify the defendant of that material breach. Then I am required to give him time to rectify or resolve.
That is as per the terms of the lease. According to you, you have complied with that. They have failed to make good that defect.
So, my lord, G1 is attracted, and then, my lord, kindly comes to H on the expiration of a notice to determine the lease or to quit or the intention to quit the property leased duly given by one party to the other.
There are two different things. If you on H, then 114 will not be applicable. If you are on G, 114 will be applicable. Because 114 will be forfeiture for non-payment. Forfeiture 114 is only on forfeiture H. That relief they will not get. So
kindly see plaint averment once again, my lord.
Plaint averment proceeds reading of the plaint, it prima facie appears that it's on forfeiture,
Kindly comes
not
to
on
my-
age.
Kindly comes to 12 and 13. Para 12 and 13.
Yes. Paragraph 12 and 13. Yes, remedy the defect. So it's basically not 108. Sorry, 106. Notice under 106. Because it's on G, not on H. So, because 106 language, if you see, it's in the absence of any contract, a lease of immovable property shall be deemed to be a lease such and such on the power by 6 the lease of for any purpose shall be deemed to be a lease terminable on the part of this by 15 days, notwithstanding anything contained in shall commence from the date. Notice under section 6, every notice under section shall be in writing. So this is when this notice is served, that's determination and the suit can be filed. So this 12 is in effect of certain conditions in the lease deed for which you are required to give notices to remove.
111G.
So
G read with
now
114.
if it is 111G, then they have a right.
114.
114.
114. My lord, even then, my lord, the provision in order 13A was, my lord, when it was incorporated, this was already there. Even then, my lord, in a situation like this, my lord, it is not that if I can satisfy that he does not have a real prospect to defend the claim of the plaintiff.
There are two things. Your claim is eviction. Ground is forfeiture. Now, 114 gives him a relief or a right to make good that.
That has to be
If that is-
exercised.
If that is done, then no eviction.
My lord, kindly comes to
If that is
114.
done, then no eviction. So
Kindly, my
then
lord,
whether in such a type it can be said that that second limb of order 13A rule 2, I think, or rule 3, that clause, no reasonable, what's the language?
Yes,
The second limb,
defendant has no real prospect of
has no real prospect.
successfully defending the claim.
Yes.
Real
So-
prospect of
So if
successfully
the
defending the claim.
statute gives him a right,
My lord, there are
till now he may not have, but it can be this 114 right can be exercised till which date?
my lord, kindly comes to 1141.
So Mr. You want to argue? Yes.
Where a lease of immovable property has determined.
Where you are
My
placed?
lord, 114 first.
114. Yes. Yes.
Where a lease of immovable property has determined by forfeiture for non-payment of rent and the lessor sues to eject the lessee. If at the hearing of the suit,
Yes. At the hearing of the suit. So he may come at any time. At the time of hearing of the suit. That's the right given under the statute. So if that right is given under the statute, can you at this point of time say, no, he has no reasonable ground to defend, or that language under
my lord,
order
this-
13A?
my lord, according to me, my lord, the language
Because this is the
114.
right protection given to him by the statute to the lessee when a suit is brought under 114G.
My lord, the language in order 13A rule 3 and the language in 114, my lord, has to be read in the context.
But if
My lord,
substantive
114G,
right, it's the
Un-
procedural part. Civil procedure code, that is the procedural part. If the substantive right gives him a right when a suit, it's purely a suit for eviction. Now you are treating it as a commercial suit before a commercial court, procedures are expedited. That's purely procedural part. But when the substantive right is being conferred upon him to make good that default, and that is at the time of hearing of the suit. Maybe at the time of hearing he may point out, yes, suit may be dismissed. He may not come up and volunteer to say. Even at the time of just before the passing of the suit, he can come and say, I'm making good that default.
But then, my lord, the procedure in my lord order 13A becomes, my lord, nugatory.
That's the thing. So can you, for that, the substantive right can be taken away. Procedural law can take away the substantive right of a party.
My lord, the prospect of defending,
Yes,
successfully defending
prospect
a
is
claim,
there. Statute
Pros-
gives him a right.
my lord, that is not, my lord, defending.
What is the defending?
My lord,
Defending an action of eviction. Defending an action of eviction, according to you, since he has violated the terms, has not paid in accordance with that, he is liable to be evicted. You have brought an action for eviction on the ground of forfeiture. Now, the statute gives him a right. If a suit is filed on the ground of forfeiture, then he can make good the default. If he makes good the default, eviction decree will not be passed. That's the right, substantive right given to the lessee under the Transfer of Property Act. That cannot be taken away by saying summary judgment. You have to apply, come now and say, make good the default.
This conduct could have been expressed when, my lord, this application was being heard. Even lordship wanted to
Statute
test.
gives him a right at the time of hearing. Why he will come at this stage?
Well, that won't be weighing, my lord, equities here. My lord, lordship is, my lord, dealing with now a commercial dispute in respect of a commercial space where a defendant
That
from
is, Mr.
2020
Dotto, that
is occupying,
I-
my lord.
I appreciate
At
that.
times, my lord,
That's the procedural law, Mr. Dotto. The Commercial Courts Act, these provisions, it's only procedural how these proceedings will be conducted to expedite, practically to expedite these things. Now, in order to expedite this, whether a substantive right can be taken away, which says uh, at the time of hearing. Now, what does it mean at the time of hearing? It has been
my lord, gives me 1
explained.
minute.
Yes, Mr.
My lord, comments, Mr. Mitra, my lord.
Yes, yes.
I would once kindly come back to one of the transfer.
Page. Yes, yes.
G.
114G.
By forfeiture, that is to say, in case the lessee breaks an express condition which provides that on breach thereof the lesser may be. And then my lord H. Or my lord after that. After that, my lord kindly in part of G. And in any of these cases, the lessor or his transferee gives notice in writing to the lessee of his intention to determine it.
Yes.
And then H, on the expiration of a notice to determine the lease or to quit or intention to quit the property lease duly given by one party to the other. Now, my lord, my notice was a composite notice. My notice was a composite that you pay. That is my lord G, and the next part is H.
So according to you, you have invoked both the clauses. So if G is there, he has 114.
I have H also.
Yes. But if G, once you have instituted a suit under G, he has a right under 114. Maybe you are under H, but he, by that, you cannot take away his right under 114. Because there are decisions, Mr. Mitso, you are aware that simpliciter in the suit under section 106 forfeiture is not available. But in a suit under G, G forfeiture, language is also very clear.
Yes.
So when that is the ground, then he is entitled to, as per the statute, to make good that. Because law gives him that right, and that's the substantive right. And that is available as per the Transfer of Property Act. At the time of hearing, he can come up and say. This is one thing which is troubling.
Very well. Well,
This is
I
one.
know my lord, at the time of hearing, my lord, I will kindly give me a day's time, my lord, I shall try.
One and another part, while Mr. Dotto was making this argument, I must put this point to you also. Yes, because if you kindly come to 13A once.
That should be good.
13A 3, Rule 3.
Yes.
Rule 3, the court may give a summary judgment against a plaintiff or defendant on a claim if it considers that the plaintiff has no real prospect of succeeding on the claim. We are not on this, because if the defendant comes up and says the defendant has no claim, that will, so you are not on this, you are on the second claim. Or the defendant has no real prospect of successfully defending the claim.
Yes.
So you are on this.
Yes.
Now, kindly come to 2, Rule 2. An applicant may apply for summary judgment at any time after the summons has been served on the defendant, provided that no application for summary judgment may be made after the applicant by such applicant after the court has framed the issues in the suit. So the window is after service of summons,
After summons and before issue.
prior to. Now, my question to you is, if the defendant approaches, sorry, if the plaintiff approaches for passing a judgment for summary judgment, whether it can be done, because whether the defendant has any real prospect of defending, it has to be disclosed in the written statement.
In the objection also.
In that
event, my lord, in my submission, the language ought to have been in 2. The language ought to have been, my lord, that an application may.
That is Rule 4, Sub-Rule 3. 4, Sub-Rule 3. This A to F.
Yes.
A to F. According to you, if you see sub-clause 3C,
Yes.
Mr. Dotto, please.
Yes.
That is what Mr. Dotto was also referring
And, my
to.
lord, in that event, my lord, what your lordship is, my lord, contemplating, my lord, in that event.
So according to you,
Rule 2 ought to have said an applicant may apply for summary judgment at any time after filing of written statement.
No, there are two, because there are two cases.
Yes.
Because it gives a right to the defendant also.
Yes.
So in a case, let us take a hypothetical case where the defendant comes, he has received the summons. After seeing the plaint, he says, this plaint cannot be maintained, so I will apply for summary judgment for dismissal of the suit. For dismissal of the suit.
Order 7, Rule 11.
Yes, that is what I was telling Mr. Dotto. The tests of Order 7, Rule 11 will only be considered then. Then it may not be required, because if that was said that after written statement, so in all cases, that's the purpose for which their written statement has not been stated. But here it will depend from facts to, if the plaintiff comes, then it's the defendant to show the real prospect. Because Mr. Dotto was saying in the original side rules, this type of suits were filed. Yes. So my question to you, whether this point was considered real of defending, what does it mean? Whether it will be by written statement or this can be said to be defending.
No,
it's one thing.
I shall again consider
Yes,
that.
it's
But
one.
kindly also your lordship pointed it out, Rule 3.
Yes, Rule 3. Those are there.
That is the defense.
Those are there defense. One thing is to disclose by way of a reply and a written statement. These are the two. So maybe prima facie you may say, but it's a judgment, Mr. Mitro. It's a
final judgment. Yes. So, my lord, it's something higher than written statement. Something higher than written statement, for the simple reason that, my lord, after written statement, my lord, the defendant gets an opportunity to lead evidence.
Because only one thing, reply will be, because you are filing a suit.
Yes.
Sorry, you are filing a plaint.
Yes.
So now thereafter you are filing an application.
Yes.
Saying please pass a summary judgment for this. Yes. To that application he is filing the reply.
Yes.
So for that these conditions say that I have to say when you are paying that summary judgment, please pass summary judgment. You will also have to indicate on what grounds. In the reply, he will say, no, I have a real defense. He will have to disclose. That's one way or the other. Second is, it will be a judgment. Judgment will be based on the pleadings. One pleading of yours, defense is the written statement. So you are having a plaint. Please consider this. The plaintiff is having the plaint as well as a supporting application also to have a claim or a judgment on a summary judgment. But the defendant only on his reply, a summary judgment will be passed without his written statement. It's a judgment, rights are being decided, claim is being decided, decree will be passed. And judgment has to be adjudicated on the basis of pleadings.
Because
Those reply and other things are not pleadings.
chapter 13 also, the original side rules, which is still continuing, that also, my lord, does not contemplate written statement. Identical thing,
Similar language.
more or less, if I remember it
Please
correctly.
check up whether this issue has been considered in any of the judgments.
Maybe.
Because if more or less similar provisions are there, now at what stage? Yes, though two outer limits are there, service of summons and the issues. But in between, whether if the plaintiff wants to have a claim, whether the written statement prior to this,
There
can
we
be-
got the provision, if I remember it correctly, is that after service of the summons, but before filing of written statement. I will bring it.
Please check up this. This
But
is
here
one
it-
aspect. The other is what is troubling is 140. If that is so, whether at this stage and at the time of hearing, there are decisions, please consider those.
Definitely.
It's at the final hearing also.
Definitely.
Just after the evidence also, one may come up and say, yes, I'm making good
That
this
is
default.
why, my lord, exactly, I will try to, my lord, elaborate my submission on this. Hearing, my lord, does here, in this case, would be the final hearing of, my lord, the order 30A application. Because they know this is the final. Your lordship will have to read both the, my lord, statutes together. And, my lord, if that is read, my lord, in my next submission, I shall try to make, my lord, further submissions on this. But according to me, my lord, they know that.
Now the Commercial Codes Act 13A has come. Whether any interpretation of this on 114 is there. Because
I'll check.
both are all India statutes. Transfer of Property Act must be decisions will be on the.
I'll check.
Yes, what is your submission?
Taka debe.
No, we have been tendering the rent altogether, but they have been returning.
No.
After the COVID period.
They are not paying, my lord, the rent as per the lease deed. My lord, had they been paying, this dispute would not have happened.
No, after that, now.
Not as per the lease deed. Lease
Till
deed.
now you are not paying as per the lease deed.
Yes, as per the lease deed.
No.
Now Mr. Mitra is
There
saying,
cannot be any dispute on facts.
no, not
Because
fact.
lease deed specifies from which period what will be the rate. There cannot be any dispute on that.
Yes, the
Yes,
periodical
can be
and-
dispute that you are tendering, he is not accepting. Might be reasons there are pending proceedings.
No.
But according to Mr. Mitso, you are not tendering at the rate mentioned in the lease deed.
the periodical expansion.
Yes,
That I
that-
will take in, sir. That I will take in.
that's under the statute. You may say even if you succeed on the force majeure clause for that period, after that,
force majeure.
No, it has to be-
also, my lord, I would demonstrate before.
even if highest they succeed on that, even if they succeed on that, after that the lease period revives, that terms revives.
Right, Mala, if the
Even
forfeiture
if you
goes,
contend that for that period it remains suspended, or he may not even highest, that is the highest which you can make an argument. But even after that, those periodical enhancement and other things, that also has to be.
Yes, because if the forfeiture goes, then I have to act as per the terms. And if the
Yes.
terms is saying that there will be a periodical enhancement, the enhanced rate has to be paid.
That you are not paying.
Not that whether at the enhanced rate or not, that I have to take instruction on. But it has to be paid. কি করছে আগে পুরনো rate এ?
Are you agreeable to the original rate if they pay? If they pay at
Original rate.
no, original means not the original. I stand corrected. As per the rate mentioned, as per the terms of the lease. As per the terms of the lease, and lease is till which period? 2028.
8.
After all, you are enjoying a
Of course, man.
large commercial space.
45,000 or something.
You are enjoying a large commercial space,
VIP.
and you agreed to that. Maybe due to the COVID, you are taking this advantage. But for that, could not have taken this plea.
Unfortunately, my lord, COVID, unfortunately, neither here nor there, did not absolve my client of its liability.
Yes, that's Mr. Vitso is on. I will consider that when on merits. But after COVID, you cannot say that any other rate. After all,
I
you are
will take
also
that
enjoying
into
the
consideration.
property, you are exploiting it for commercial purpose, not for a residential
Notice
purpose.
was given, my lord, even if they paid it, possibly, my lord, this would not have arisen.
Heard Mr. Mitchell, and its senior advocate. In case there is no 330, Mr.
Yes,
Mitro,
very
it may spill over to some.
good.
Yes, call the next matter.
আমাদের 25
25. 24, what happened?
I am the state, my lord.
You are the state.
24 minute I am the petitioner.
Yes.
My lord,
The report was called for my.
Oh, this is
Ajay,
state
Ajay,
matter. Oh, report, you have filed the report.
Yes, yes.
May I get a copy?
The report in the form of an affidavit filed by the matter.
They appear for the respondent.
Yes, Mr. Chakraborty, your matter has been reached.
Yes, Lord.
You are inquiring from the learned, you are disturbing the learned advocates. How long they are meeting?
No, I had one matter with
Wrong.
Justice Sarkar. I had one matter with Justice Sarkar, so I was
Yes, you wanted that how long it will take.
that
You
was
were
taking
disturbing when they were.
I'm extremely sorry if I've disturbed the court.
But his presence is inevitable, man.
এই তো এসে গেছে আসল লোক এসে গেছে চলো
Yes.
His presence is inevitable.
Lordship may kindly take your lordship last order.
My lord, so far as before your lordship takes up, my lord, may I just request?
কোনো টাইম পাইনি না
আগে থেকেই বলে দিচ্ছে।
আমরা
May I say this, my lord?
Jurisdiction.
Yes,
No,
my lord.
All matters are jurisdiction matters.
Your lordship has dealt with that. Kindly take your lordship's order.
Are dealt with.
Lord,
Yes, your lordship has formulated the issue, and your lordship called
Yes,
upon
it
the petitioner whether they want to withdraw or they want to contest. And the adjournment was sought for on that ground alone.
4B2 and 6C
4B2 and Rule 6C.
LRTT has jurisdiction.
Yes, Mr. Vasu. Yes.
no, my lord, what Mr. Mojumdar submitted, my lord, may I say this, my lord, running with fever, my lord, not very well. If I could be accommodated, my lord. I would even, that is why I could not, since my lord, I thought that my presence has to be there, otherwise Mr. Chakraborty would not,
I cannot
running
oppose
with fever
anybody
for-
suffering from fever, but
Must-
only that instruction
not-
whether they want
not
to
very well,
contest
my
or
lord.
not, that we should know.
That we should
Yes,
know.
of course, we would,
Mr.
of course, we
Vasu,
would come.
Mr. Mojumdar wants to know whether you want to withdraw or you will contest.
We will
Make
contest.
officials on merit. Because if,
My lord, we'll make,
if you want to withdraw, Mr. Mojumdar may.
Then
No.
there is nothing.
no, we don't want to withdraw. That is very
want
sure.
Then, my lord, kindly post this matter tomorrow.
Maintain with
Why
the-
tell your lordship, my lord, we are facing a three-pronged attack.
Yes.
My lord, one PIL has been filed.
Well, that
Where
could be
pleadings are made with regard to this. PIL has been filed with respect to the same land, where pleadings have been made with respect to this particular educational.
So I'm saying that let this be tagged along.
No,
with
no,
the
no.
PIL.
It's a different.
That's a different issue.
That's a different issue.
That's a division.
No. That's a different
That's a
issue.
different issue.
That's a different issue. Your lordship.
My-
No. There is no overlapping. There is no prayer.
There's no prayer.
There is no prayer to that extent.
There's no reference about the
It is
school.
all about the bus terminus.
Yes.
That PIL is about the bus terminus. A local passenger says
No.
that the bus terminus cannot be removed from that site. This is about the educational institution. Kindly, my lord, kindly.
So tomorrow,
Well, Mr. Mojumdar may not be correct, my lord, entirely. It is
Alright,
not with
tomorrow,
regard to-
tomorrow, I'm keeping it tomorrow.
my lord, kindly give me, my lord, 1 to 2 time. Not very well, my lord. I could not come today. My lord, I do not say, my lord, that my favor would
Friday,
suddenly,
my
my
lord.
lord.
Friday. I mean, I will.
Kindly,
Friday,
my
Mr.
lord, kindly keep it, my lord, next week, any day, 10, 11, 12, 13, any day, my lord.
9th.
9th.
Except 9th.
Monday.
Monday,
at 2 p.m.
Monday,
Except 9th. 10, 11, 12, 13.
except
except 9.
10, 11, 12, 13, any day.
Malad, it's night 10th. Malad, I have my personal difficulty. Malad, I may not be able to attend the court for my personal reason.
11th.
11th, I am there. Malad, kindly, Malad, post this matter at a specific time because Malad, we have been waiting for last 2 weeks. Though the matter is appearing under the head motion, but
That I
Malad,
could not say, Malad. It is my lord's kind
then
wisdom.
Malad,
Malad,
kindly
and
keep it
I'm
there.
trying
disturb
to
you, my
No,
lord.
no, I understand, Malad.
all groups.
I don't
My
want
lord
to.
always tries to
I do not want
accommodate.
to disturb your.
I'm giving preference to the forwarders matters. Some new motions because all matters.
Malad,
Some days only the motions heading. That
Malad,
is
may I
why
just, may I just,
maybe you have to wait for some days.
Malad, let it be subject to lordship's kind convenience. And the Anet friend is also here. If it is not Wednesday, Thursday, any time, 3 p.m.
I'm keeping it on 11th. In case that is not taken up.
3 p.m. my lord, 3 p.m. to 3
Malad,
p.m.
Malad, I leave it to my lord's wisdom, my lord. I usually do not.
I'm keeping it on 11th. If it is not reached,
Malad,
then you remind me.
Malad, only one prayer then. Malad, your lordships has a list which has set of new motion, new motions. It is
Yes.
like this. Malad, if it is listed under the first heading, there is one new motion heading. There is one new motion one.
You cannot go into that. That's the first day.
Then Malad, to be mentioned.
Malad,
Yes, because it is all about.
Malad,
kindly-
Malad wants to decide, Malad, how the lordship will go and how the
Heading does
Malad
not
diary
matter.
will go.
Yes.
Only if both parties are there under
Malad,
heading,
we are here, Malad. We are here, Malad. Difficulty is there, Malad. I tell you, lordship.
requires some time.
Yes.
It will require some time. Some short motions matters are to be taken up. Thereafter, I'm keeping this
Malad,
because this is.
But
just
let it not
after
be,
the
let it
fresh
not be
matter.
even, let it not be even 11th. Kindly give us a date and time.
Mr.
Malad.
My
Majumdar,
lord,
this is just
my lord,
after
Any
my
day,
lord,
any day
my lord is
thereafter.
a
But
master
I'm
of
not
my lord's
insisting on
court and
11th.
my
Majumdar,
lord's
please
diary.
see list
And here, my lord,
just after the
something.
fresh matters. Your matter is just after the fresh matters.
Right,
Please
I
see that.
understand, Malad.
But some days I'm giving preference to the forwarders matters.
But can it be new motion 1? That's the.
There is no group of new motion one.
Yes, Malad. There is one.
After please see, new motion one has been exhausted, Mr. Majumdar.
Oh, new motion 1. Malad, Mr. Chakraborty told me yesterday.
He creates confusion in all matters.
Yes. Well, Mr. Majumdar doesn't
Mr.
doesn't
Chakraborty
say
creates confusion. Please don't hear him.
কোথায় আছে এটা?
My lord, my
Yes,
lord, my lord,
where is new
petitioner
motion
even
one?
now wants to.
That list, Mr.
Petitioner now
Malad,
even
may I
wants
just
to,
pray
my
for
lord,
one
I'm
indulgence?
doing
No,
some
no,
work.
I'm not praying for
my
anything
lord's
else.
own diary
May I,
and
may I?
convenience.
No,
As much as
no,
you
I
expect.
will not make that submission.
I'm not telling you something.
Oh,
I'm
it is
telling,
him. Malad, your lordship can continue to
This
rebuke him
is
for
only
next.
after the fresh matters.
Malad, may I just humbly make one prayer, subject to whatever my learned friend would submit. Malad, it will obviously not come under the head new motion. I understand that. But let it be the first matter under the new motion 1 head, 2 heading.
Wow,
Yes,
how is it?
That can be done, my lord. হবে 10 সাহেব অর্ডার দিলে হবে।
Let it appear thereafter.
মানে some precedence under the new
My
motion
lord, this
2
can
heading.
all, my lord, this
It
can
will
also
appear
be done, my lord, so that
uh,
this matter can be so top, it goes out of list. My lord, Mr. Majumdar wants to
an
fix up
accommodation has been
diaries and
sought for-
convenience of my lords.
What? He is very busy.
KMC, 13
to 15
That's not very.
On the pair of the
Yotpal Chatterjee appeared on the last.
joint prayer of
Yes, yes, my lord. My lord, I am appealing for the KMC, my lord, led by Mr. Nilotpal
this
Chatterjee.
matter on
My lord, my lord, so far as
yes, next.
my lord, so far as item number,
Maybe remind your lordship if it is down in the list. Subject to law.
Kindly allow us.
my lord,
Chakraborty is very
my lord, item number, my
Lord,
lord, am I audible or
in all courts,
comes and mentions every alternate days.
in all courts,
my lord,
they are not moving it after the first day. Whenever we take a point of maintainability,
Difficult thing,
this
I know.
fever, everything starts. In all courts,
It's like
in all
my lord,
courts, they are getting
it's like
adjourned.
my lord a spider's web.
Yes.
my lord, am I audible to your lordship?
The web is gradually
My lord, am I audible to your lordship? My lord, so far as item number 25, my lord, I could not hear the order, my lord, that your lordship
Yes.
passed.
Junior is here. Please hear the order from your junior.
तुम्हें
My
जहाँ चाहिए
lord, you kept the matter on 11th.
Yes.
Mild. No, only this much.
Call the next matter. But your lordship can penalize Mr. Chakraborty and upgrade the matter. Yes, yes,
At least Ganta's liberty to come back on 11th if it is down.
yes.
Yes, yes.
ব্রিফটা কোথায় আমার আমার পড়া ছিল এটা এটা ব্রিফ নয় এটা ব্রিফ নয়
Supplementary affidavit. Now you are saying, Mr. Mojumdar, they are filing the supplementary affidavit now.
can come back on 11th and do this one.
Well, you are saying now, after the order was passed, you have not prayed for it.
Let us have that. Otherwise, they'll take time on that pretext.
There was no leave, I suppose.
There's no leave.
Very well. If there is no leave, we shall not.
Said this when this matter was going on.
That was not
After the order has been passed, you are saying the supplementary
that was
affidavit.
not the part of the
No, no,
plan.
my lord, may I
They are
say
left.
this?
This is not
Well,
appreciated. After they have left, you are saying you are filing the supplementary affidavit. May I take the supplementary affidavit so that I can count it?
We are accepting.
Instead of we are the supplementary leave is sought for by the supplementary affidavit. First of such leave is granted. The supplementary affidavit filed by the petitioner in court today is taken on record. A copy of the have you served?
Yes, we have
A copy of the supplementary affidavit has been served upon the learned advocate for the respondent numbers.
ওইখানে দেখ না তো এক দাদা আসতো
Has been served upon the junior of Mr. Mojumdar.
নিয়ে না ওই তো দাদাটা
Yes.
চন্ডিবাবুকে দিয়ে দিন চন্ডিদাকে দিয়ে দিন
Yes. আচ্ছা তাহলে সব upon the respondents করে দিন, upon the learned advocate for the respondents করে দিন. Yes. Yes. You appear for the petitioner? Yes.
Relates to my lord, the compensation in respect of the structure. Initially, my lord, compensation has been granted. I am not satisfied with that compensation. I have made.
Yes, Mr. Mahato, what is your instruction?
my lord on the basis of the rate my lord award has been declared now the assistant engineer has enhanced the rate but he has to take this point before the my lord 3G5
No, I could not follow. The petitioner alleges that as per the prayer of the remeasurement of the structures was made, but no communication thereafter. What happened? Remeasurement was done.
a remeasurement was done and my lord
Enhancement was
the enhancement was made but award has already been declared he has to go to the my lord 3G5
No, why should I? Your lordship kindly have.
already award has been declared
There, my lord, last occasion, your lordship passed similar order, my lord.
award has already been declared
Only one thing, then remeasurement is for what? Mr. Mahato, remeasurement is for
reassessment has been made
No,
reassessed
remeasurement and.
here it is reassessed my lord I have got the instruction that it is reassessed it has been reassessed
by which authority?
by the
Special
no
By Kala?
executive engineer
No, by
NHE
Kala.
person.
No.
Kala. By the executive engineer. Reassessment has been made,
This assessment means the compensation has been recomputed.
recomputed.
So that's a modified award then,
My
Mr.
lord, award has already been declared.
Then how could you
My lord,
assess the compensation with the modified rate? Under what provision, Mr. Mahato?
my lord, 3G5, he will take this point.
Mr. Mahato, there is an initial award.
Yes.
Now you have reassessed.
Not initial rate. Thereafter, on the basis of the rate, award has been declared. Thereafter, my lord, this reassessment has been made.
Yes. So that's by you. So you are reassessing.
No, that is, my lord, the assistant.
Under what provision you are reassessing this?
My lord, executive engineer has
Under what provision? This has to be a modified award then.
No, there is no.
Then
no,
how
no,
could you
it
reassess?
has not been
Mr.
done.
Mahato, please take 3G5 once.
Yes.
3G5 is if the amount determined is not acceptable to either of the parties, the amount on the application be determined by the arbitrator. But here what happens? After you have passed an award, you yourself has modified that.
Well, I have not modified.
Who has
But
modified?
Executive engineer has reassessed that the valuation structure valuation would be this.
How? What authority he has?
My lord,
Please
he
file a
has
report.
made representation, and on the basis of that, my lord, it has
My
been
lord,
done.
kindly have to page 29. That is remeasurement of structure in connection with the
Yes.
construction, so and so. And the
This is by the special land acquisition officer.
remeasurement was made. that
Yes.
has been done, and thereafter enhancement was done, page 30, very next page. My lord, on that basis, my lord, I am only claiming the, my lord, the difference amount. Initially, they have.
It has already been paid. The what was the
Yes, difference amount have you paid?
No,
no difference amount has not
I
been.
am paying the difference amount.
Mr. Mahato, it is your calculation, it's your document. He is not agreed by this. It's your computation.
Difference amount Lord, you are not
You are in
paying
which serial? You are in which serial?
serial number and that is the serial number 31.
31. Jaheda Bibi.
Jahida Bibi.
So, Mr. Mahato, it's your corrected copy, this office memo. So you have revised. Then you have to pay the balance. He is not agreed by this. Why he will challenge this?
Yes.
He is accepting. He is not agreed by this.
My lord can pass the direction, my lord. My lord, here the my lord, the additional district magistrate land acquisition Calcutta has written that after declaration of the final award, this.
But you have corrected only one thing, Mr.
After
Mahato, please.
declaration of the final award has been declared, my lord, earlier.
Yes.
Final award has been declared earlier.
Yes. But what do you say? Because this, Mr. Mahato 29, please take instructions on this. Place 29, remeasurement done by the special land acquisition officer. Thereafter, this computation is the corrected copy. Page 30. Now he says, please give me this. I am not agreed by that. If he is agreed, he has to challenge. Please take instructions on this. And please take instructions whether the balance amount has been paid or not.
Balance amount has not been paid.
Then
declared award has been paid.
That he is also not disputing.
My lord.
But this difference you have assessed, and he is not agreed by that. Why he will challenge? I'm keeping it in the next week. Please take instructions.
My lord.
Last question, my lord, serial number 32.
এই টাকাটা বেড়ে ওটা হয়েছে 46টা 51 হয়েছে এটাই বলছি
What order? Please show it to Mr. Mahato so that he can.
46টা বেড়ে 51 হয়েছে
Mr.
My lord, similar order, my lord.
This is in plot number what? Which plot number?
Structure number 82 and plot number 30.
Please correct the plot numbers.
Yes.
And this was passed on 21st of January. Time হচ্ছে February. By the end of March,
My lord.
the direction
This is meager amount, more than 5 lakhs or 6 lakhs.
7 lakhs only.
So I'm directing you to pay by the end of March. ঠিক আছে না? February টা শুধু where do I get the plot numbers?
Sir, plot number that is of your lordship, page 29,
Paragraph এ বলো না।
the column.
Paragraph, please take
Paragraph
me to the
2.
paragraph.
Paragraph 2.
Paragraph 2, plot number 13.
Right,
Plot
Same
number
plot.
13.
same plot. Structure number is different.
Structure number 82. এখানে structure number 83.
Number
Okay,
different.
yes,
should be
প্রত্যেক
different.
number different, এটা দেখে নিয়ে তাহলে করে দিন। LAKs and other things are all same.
Yes.
My lord.
ঠিক আছে, same order. শুধু ওটাকে by the end of March.
Great.
Yes, next disposed of.
Land of the on the land plot.
Appearing on behalf of state, my lord.
Yes.
The land of petitioner.
I am for the state, my lord.
I am for the railway.
Really.
Yes, have you taken instruction?
Yes, my lord, I have taken.
My lord.
Land, land is acquired in the year 1896 by the British government. Thereafter, my lord, I have.
Please file a report.
My lord, may I allow to submit my report?
My lord,
Not only that, this is the government land, but notified in the irrigation.
All right, please, who has given you instruction?
Yes, my lord.
Who has given you instruction? Who will file a report?
My lord, I am making submission
My
of
lord.
the report, my lord.
my lord, I am submitting.
Yes.
Behalf of state, my lord.
My lord, I am.
My lord, submit the report. Divisional
Madam.
engineer.
My lord, please come to the middle paragraph, paragraph number 5, my lord. It
Yes,
also
plot-
appears that
That,
certain plots.
are
May I
nearby
read,
the
my
land.
lord?
yes, yes.
I've recorded.
It also,
record.
fifth paragraph, it also appears that certain plots, those are around and nearby the land in question, have been recorded as either one within
Yes, Mr. Chatterjee,
bracket
this is record of rights. this
recorded
is-
বহির্ভূত ভারত সরকার পূর্ব রেলওয়ে that is government of India within bracket out of record lands, my lord.
Let them file a
Eastern
report.
Railway.
Let a report be filed by the, who will file the report?
My lord, divisional engineer, Eastern Railway, Howrah.
Divisional engineer, which respondent?
Senior divisional engineer. They are not party.
How they will file?
They are not party.
Divisional engineer.
And general manager, Eastern Railway is the party. Howrah.
General manager can file a report.
Senior
The general manager, Eastern Railway, Howrah,
engineer.
being the third respondent, is directed to. Is this matter after 2 weeks, another same heading? 3 weeks, all right, 3 weeks, list this matter after the 3 weeks. Yes, next.
Deeply obliged, my lord.
28, yes.
My lord, report and রিপোর্টটা দেবেন রিপোর্টটা নাকি রাখবেন
Yes, who is for the state? Yes, who is for the state? What do you want? Removal of encroachment? Yes. What submission? You want removal of encroachment by the private respondent.
Only one day.
You are his junior, madam. You are not ready. On the prayer of the learned advocate for the petition.
I am appearing on behalf of respondent number 8, my lord.
Yes. Yes, what is this matter?
That's the removal of the encroachment, my lord.
Yes.
As your lordship is not regarding this notification, my lord, as per the new notification, my lord, the DM is the actual authority, my lord, to remove this all these encroachment. If your lordship kindly pass the order, lordship, as the district magistrate is also part, this for number 3, yes, for number
Who is appearing for the district magistrate?
my lord, the state.
Nobody is appearing for the state. Yes, Mr. Bandyopadhyay. Mahato, why nobody is appearing for the state?
State has not been added as a party, only Union of India. Union of India.
State is not a party.
No, my lord.
My lord, district magistrate is the party. my
Yes,
lord.
district
The-
magistrate is a party.
party, my lord.
Block land and land reforms officer is
Oh,
also a
okay, as
party.
a district magistrate.
Police is also a party. They are not under the state, Mr. Block land and land reforms officer, block development officer. How many more you want, Mr. Mahato?
Unless the GP, my lord, the readily available advocate will not be there.
You have not served upon the GP.
Yes, no service upon the
You have served.
GP.
When have you served? You are for the petitioner. I am asking, have you served upon the government pleader?
Government pleader.
No.
You have served. All right, Mr. Bandyopadhyay, please appear. The learned
No, no.
yes.
Copy the Mamla.
Mining for extraction of sand issue. The lease is pending. My lord learned that under the 2021 rules, now for transportation, I need to have permit. That the validity of
For transportation.
that the validity of the permit to that has since expired. I could not transport. I could extract, I could not transport. But in view of the various situations, including the monsoon season, that I have made representation, which my lord would kindly will not get from page 113 onwards. But before that, my lord kindly comes with at to page 111. This
Yes.
is one of the permits which has been issued.
Yes.
My lord kindly sees the permit date on the right hand side top, 8th of June 2025.
Yes.
Now, my lord kindly see not the last paragraph. That hence prayer for excavation permit for so and so is hereby allowed in favor of so and so in respect of sand block under so and so with validity from. Now kindly sees the period.
2nd of May to 8th of June.
And it has been issued on
8th June.
Right side top.
8th June.
It is issued on the 8th of June. The validity is expiring on the 8th of June. Then Lord kindly sees the next page. Lord, I make a representation.
It's a good. It's wrong.
Yes.
So let them be a little more reasonable to me. I am saying that.
Mahato, how can this be?
This is a glaring mistake, my lord. My lord, memo is issuing on 8th June.
It's expiring on 8th of June.
8th of June and from 2nd May. My lord, this is my lord. This is glaring mistake.
So you consider this representation
My lord,
pass or
representation
order?
be considered.
Where is your representation?
Page 118 is the last part.
Yes.
118.
But Mr. Chaturvedi and Mr. Mahato, what is the provision for this extension of this permit?
My lord,
There is only rule 15 of the 2021 rule speeds of transportation.
Transportation.
With a permit.
With a permit.
It has no provision with regard to extension. In another matter, I shall take up a point and I shall argue an interesting point. Now what they are doing is, the moment the permit expires, they say you are in illegal possession of
Transportation.
Because
penalty. I say I am a lessee when these rules did not come. How can you invoke a penal provision retrospectively?
only one thing, Mr. Chaturvedi, under some statutes, GST will be finding those e-way bills for transportation. There is a time limit also. Now, there you will be finding the GST boita dekhi. The provision for extension.
Yes.
So then what will happen then? If there is no provision for extension, what will happen then?
That is not precisely what I am not. I'm happy I could be arguing before my lord.
What is the meaning of that?
Well, the meaning of that is that what is troubling me has already reached my lord. It's also troubling my lord. And so what would happen if there is no provision? Because rule 15, it stops at only with regard to permit. 2002 rules, they say as to when will the stock be treated as an illegal stock.
If there is no provision for extension, there has to be a fresh issuance of a permit. Because Mr. Chaturvedi, the moment you say there is a validity period, it has to be given some meaning. Otherwise, it will carry. Now the question is whether immediately after that expiry penalty can be levied. That's another thing altogether. But if the rules or orders or the statute provides that this transportation has to be under some document, that's the permit in this case, or any challan, with a validity period.
No, it doesn't say a validity.
Yes, validity period it says.
15 for a moment.
Where is rule 15?
There's the 2021 rules.
You have a copy of the 2021. Rule 15, yes. Prohibition.
Prohibition on transportation, storage, and
Sale.
of sand.
No person shall transport sand without being duly authorized and carrying a valid internal permit challan generated on central product. So without, And this challan, as you have shown, all challans will be having a validity period. Otherwise, it cannot be, some validity period has to be given to some challan.
Lord, I put a question to myself. Lord, my Lord agreement is Lord, but the lease agreement is before the 2021 rules coming into force. Now, state Lord is bound by its promise. There is a division bench judgment, Lord, judgment delivered by Justice Bhattacharjee. Lord saying that Lord, retrospectively my right Lord vested under the contract cannot be taken away. That Lord
That cannot be taken away. That's
now the lease agreement, it does not say that I will be subjected to any further permit being being mandatorily used, or that if I don't use it, I shall be not levied with penal charges. That
yes.
means now the state
All right.
is,
So where is your representation
page 118
to
is
issue the excavation permits for this?
115 my lord, he
That
was
was
given
excavation permit.
excavation permit was given 115.
Yes.
That is up to 20th December, and now his representation is 118.
Yes.
আচ্ছা ওর
Also
এটা তো
13th of-
16 রুলস অনুযায়ী তাই তো লিস্টটা
But Mr. Chaturvedi, the 115 is also, the permit was
Execute.
being extended from time to time.
Yes.
Yes.
One time. It was extended. 115 it was extended.
All right. The petitioner